Good morning. Can everyone hear me?
Good morning, everyone. Can you hear me?
Yes, we can.
Yes, I can.
Yes. Right. Good morning. I do not see the prisoners. Already be recording. Good morning, everyone. I do not see Ms. Greening. Is Ms. Greening on the call?
We don't see her, Mr. Quayler. I will message her.
Thank you. Well, apologies to the members of the court. The position is that we are waiting for the prisoners to be produced, and also it appears that Ms. Greening is not on the call yet. Sir Christopher, if you're saying something, your mic is muted.
All I said was yes, in a rather resigned manner.
Mr. Quayler, I just spoke with Ms. Greening. She'll be on momentarily.
Thank you, Mr. Pettingill.
I should warn you that, as you can see, I'm at my home, so there may be occasional noises off. I hope there won't be, but...
Does your lordship have a hound?
No, I do not have a hound.
Yeah.
I have a wife who is... but she won't mind me saying she's slightly deaf, and therefore people tend to ring the bell in an irritated fashion.
Right.
Mr. Quayler, I have a concern that I think that prisons may have thought it was 9:30.
Oh, not.
That's because someone said that.
Do we know what the position is about the prison? Ah,
There appears to be
Somebody.
some movement, so yes, this looks like to be them.
right.
All right. All right, good morning, gentlemen. Mr. Smith Williams, Mr. Brangman, and Mr. Roberts, can you hear me?
Morning.
Good morning.
Good morning.
Gentlemen, can you hear me?
Yeah.
All right, excellent. So good morning, everyone. This is the Court of Appeal for Bermuda sitting on Tuesday, the 9th of March, 2021. We are hearing criminal appeals number 489 of 2020, LeVeck Roberts, Quincy Brangman, and Kyrie Smith Williams against Her Majesty the Queen. Ms. Victoria Greening of Resolution Chambers is representing appellant Roberts. Mr. Jerome Lynch QC and Ms. Sarah Ann Tucker of Trotton Duncan Limited are representing appellant Smith Williams, and Mr. Mark Pettingill of Chancery Legal Limited is representing appellant Brangman. These proceedings, I'm sorry, and Mr. Mahoney and Ms. King Dean are appearing on behalf of the Queen. These proceedings are taken before my lords, the President, Sir Christopher Clark, Mr. Justice Jeffrey Bell, and Mr. Justice Anthony Smelly.
Right. Good morning, everybody. Thank you for coming slightly earlier than usual, so far as you are concerned. And thank you also for the responses to my recent inquiries. I don't know whether you've discussed how the appellants proposed to address the matters amongst themselves, but we have it in mind that the parties, both the appellants and the respondents, should address the issues of principle which were set out in our letter of the 1st of March, including how you count somebody to be a standby, and that we should do that, that after we have done that, we should address the new evidence questions. And then at some, possibly next week, we would, to the extent necessary, having had the discussion about the principle, go through the standbys, because in relation to some of the cases, well, in relation to Brangman, the Crown only accepts that there were 3. In relation to Robarts, the Crown accepts that there were a lot to start with, but as I understand it, that you ended up with 2. And in relation to the 3rd case, the Crown, as I understand it, accepts that there were 6. But it may therefore be necessary, to some extent, to go through the individual standbys and see what happened to them at the end of the day, by which I mean second time round. But it seems to us that that could be much better done as a standalone arrangement by itself, after we've had the argument about the matters of principle. I should also give notice that I have asked Mr. Coelho to produce a separate bundle, which I hope will be available soon and is particularly needed for the how do you count the standbys exercise, which contains the unamended provisions of section 519, the jurors, section 15 of the Jurors Act, and the schedules of the Crown and the responses thereto in relation to standbys, In relation to Roberts, the Crown's list is there's an amended list, page 410 of the Court of Appeal. And we have a letter from Miss Greening, which says that she doesn't argue with the Crown as to the number of standbys, those excused, challenged, or who eventually sat. It's not clear to me whether that's an acceptance that at the end of the day, only 2 people were stood by or not. The next item in the bundle is the Crown's list in Smith Williams, where the Crown says that there were 6 standbys, and Trotton Duncan's letter of the 26th of February to the court, which says, yes, there were 6, but there are a few others as well. And then the next document is the schedule of the Crown in relation to Brangman, and the submissions of Mr. Pettingill of the 13th of November 2020 on jury selection in Brangman. In other words, what there will have been composed is a self-contained bundle dealing purely with the how many got stood by in the end question. It seemed to me that it'd be much more convenient to have that bundle rather than to grubble around in a much bigger bundle trying to find individual documents. So that should be available today. I simply give notice that it will be. Now, I don't know whether you've even agreed as to who's to start.
Morning, my lord. Mr. Pettingill for Mr. Brangman. Yeah. My lord, thank you for your questions in the letter of March 21st. Your lordship will see that I have responded in some detail on a point-by-point basis to each of those questions, which I have discussed with Mr. Lynch, who has also responded with some additions to that. The suggestion between us, if it's amenable to your lordships, is at this stage that I would perhaps go through that response, and that between us we could entertain anything that arose in relation to those particular preliminary points.
Yes. Sorry, when you say Mr. Lynch has got some additional matter, have we had those? Or are they incorporated in what you sent us?
There's an addition, my lord, I think.
Yes, I wrote to the Court of Appeal through Mr. Coelho last week after we'd received these particular questions from the court, indicating that that is myself and Miss Tucker were in court all week on a matter, and therefore we would not be able to address them until later, although we intended to do so, and indeed we did, and I filed it at the weekend. So I'm sorry if you don't have it as yet. I don't know if it's in the bundle itself. Hang on, in there.
I wonder whether Mr. Coelho can help.
I'm just having a look. Do you know when you sent them over the weekend, Mr. Lynch?
Sunday. It arrived on Sunday.
Oh, the blessed day.
Yeah.
Good morning, my lords. Just to indicate that I'm having difficulty accessing the record of appeal bundle. I have indicated this to Mr. Coelho, and I'm still unable to access it online.
Ms. King-Dean has indicated she can access it. You still cannot access it, Mr. Mahoney?
No, I can't.
Okay, to the members of the court, Mr. Lynch's submission that came in on Sunday has just been sent to you by email.
Oh, right.
I mean, at this stage, that doesn't really matter anyway. we're at item.
Received, Mr. Queller.
Thank you. Mr. Mahoney, a link was sent to you and Ms. King-Dean this morning to try to access the link. Did you try that link?
I tried it and still nothing.
Right.
Wait a moment. This is confusing. I've seen this document. It's headed responses to questions. And it begins, paragraph 1, in our submissions of the 15th of February, at paragraph 2, we postulated the following questions.
Yes.
And I read all of that.
Your
But
Lordship.
that is signed. That's from
Trotton
Mr.
Dunn.
Lynch.
Yes, and Ms.
Yeah.
Tucker.
Yes,
And
yes. But that I've got. But is there something from Mr. Pettingill that I'm missing?
No, you have a full, my lord, you should do. I filed a full submission from me last week on the 5th of March.
Mr. Pettingill, there was something that came into the court, I believe, yesterday. Justice Bell has a hard copy of it. I've just sent my assistant to scan the court copy so that I can forward it to the other 2 justices.
I didn't have it.
No.
So is this a document dated the 5th of March?
It is, my lord, yes.
Well, we haven't got that.
Is that what, Mr. Queller, you're referring to?
Yes,
Yeah.
for some
We
strange
have a
reason,
hard copy.
although it's dated the 5th of March, it only made it to my desk yesterday. So I've given the hard copy to Justice Bell, but the spare copy I'm having scanned so that way Justices Clark and Smelly could have it.
Well, okay, we'll get it in the end, but I haven't got it now. Is it long?
It's not extensive, my lord. It's some 5 pages addressing all of the points in order that your lordship raised.
Right.
And I had certainly
Okay,
wanted
well,
to in advance.
Okay.
Is it said, Mr. Pettingill, that this is in response on behalf of your client as well as Mr. Lynch's?
My lord, Mr. Lynch and I had discussed it, and after I had filed the submission, Mr. Lynch had the benefit, I hope, of having read it, and we are effectively ad item on the responses to his lordship's questions.
I see.
Well, that may solve a number of problems, but okay, please provide us, Mr. Queller, with that document as soon as possible.
It has just been sent.
Oh, I see. Okay, let's pause for a moment.
Have you got his submission? Thursday.
Thursday.
Yeah.
Oh. Right. I have now managed to open that. Okay. Right. Okay. Well, we got it now.
To rise for 5 minutes.
Right. Well, let's see how we go.
Would it assist with your lordship? I mean, I'm happy to move right in, or would it assist to rise for 5 minutes while your lordship had a scan of that?
I think it might. And I'll point it out too. Can we go to a meeting room, Greta?
Yep. Everyone else can remain on the main room, but just mute your mics and turn off your cameras. So Christopher,
Yep.
Can you access the judges' breakout room?
Oh, sorry. I don't know how.
There should be something in the lower right-hand corner saying "Go to breakout, join meeting."
Well, it says, oh, join, wait a minute. Yes.
Okay.
Yeah.
He's on mute. We're on mute. He's on mute too.
Thank you very much for that. I've read it, as you can see, quite quickly, but that's very helpful.
Thank you. My Lord, could I just confirm for the record that I've checked and also spoke to Mr. Coelho. It was actually, and I appreciate it's a time of COVID and these things get missed, but it was actually filed and stamped and served on the 5th of March and sent around electronically. So I apologize that I'm sorry it got missed, but somewhere it got lost in the mire, it seems.
Yeah. Well, it's a problem with doing things remotely.
Absolutely.
Okay.
So your lordship content for me to then just proceed and go through it?
Yes, absolutely.
Thank you.
But which one are you going through? Yours or
I'm going to go through mine. I'll go through mine, my lord. I'll leave Mr. Lynch to his.
Okay. Right. Okay.
My lord, could I start, please, by, I think that the key document for your lordships to have in hand, of course, is the case of the ruling of the learned Chief Justice in Trott.
Yeah.
Is probably, in my respectful view, the most significant authority in all of this proceeding, because it really captures unappealed all of the key issues of this constitutional matter on the jury issue, and most importantly, really prompted the change in the legislation. So I intend to reference it on a number of occasions. But if I could, and this is an important point with regard to the first issue I'm going to raise with regard to finality. But if I could just commend to your lordships the conclusion of his lordship at page 59 of Trott. And Trott is contained at page 142 of the record, my lords.
I think you mean paragraph 59.
I do in fact mean paragraph 59. Thank you, Lord. Thank you. Paragraph 59, page 23. At page 140. And his lordship states, having regard to the reasons set out above, I am satisfied that the disparity between the accused persons and the Crown's right to challenge jurors gives rise to a real possibility that the jury may be biased in favor of the Crown. Such a state of affairs offends the appearance of impartiality on the part of the jury, which is an essential element of the fundamental right to a fair hearing by any independent impartial tribunal guaranteed by section 6.1 of the Bermuda Constitution. It follows that the provisions of section 5192 of the code are inconsistent with the fundamental right to a fair trial established by section 6.1. His lordship makes very key use of the word fundamental in his conclusion as to the issues as they relate to section 519 of the Criminal Code and jury selection in section 6.1 of the Constitution. That is a significant point in and of itself with regard to the first issue that your lordship raised, which I'll turn to.
Mr. Pettingale, I'm sorry, but I've just noticed that Mr. Mahoney has been lost from the call.
I'm sure he hasn't run away, but
no, he's just called the office to indicate that he's been booted off the call. Ms. King-Dean, are you able to pop down the hallway and assist him?
Absolutely, I can do that.
Thank you.
Thank you.
Give me just a second. I need to adjust something.
in one room, you know, and done it that way. I mean, they've got. Sorry? You didn't send it. Sent it to everybody. I've just asked him to upload it and send it to everyone. He hasn't, as far as I'm aware, he hasn't come back and said he hasn't got it. Maybe it's just the Court of Appeal chamber, wasn't it?
I can confirm that you have that. Sorry. We're awaiting the paragraph explaining the use of that. You said that. No. They got the case.
Okay, there appears to be a technical difficulty with Mr. Mahoney, so Ms. King Dean is going to transfer offices so that they can join collectively,
Right.
so that we don't lose any more time.
My apologies, my lord. I'll just take my laptop to Mr. Mahoney's office.
Right.
All right. Thank you, Mr. Pettingill.
Um,
Sorry about that.
I just briefly, my lord, for Mr. Mahoney's benefit, I was highlighting the fact of the ruling in the uncontradicted ruling in Trott of his lordship, Chief Justice, about the fundamental right to a fair hearing. And if I could just say this, my lord, one would have to argue that it's clearly deemed to be fundamental, and I say that so it really puts aside any issue with regard to the constitutionality of the position not applying retroactively. But also one would have to question what I say is the afterthought, and I'll come to this, of the legislature including Section 5 as a saving provision. If they hadn't viewed it as being fundamental, they probably wouldn't have needed to include a Section 5, because then the principles that are set out in cases like Arbor would have addressed the issue of constitutionality being retroactive, but they didn't. They included Section 5 in that. But it just, to my mind, highlights the point that this is a fundamental issue pertaining to the right to a fair hearing by an independent and impartial tribunal. So, my lord, having said that, if I could turn to my submission and response, the most recent submission, and perhaps just go through that. My lords, I've set it out, endeavored to addressing each question in your lordship's letter. So the submissions are made in response to the letter dated the 1st of March, and address those issues. So the first question that your lordship raised was the principle of finality, and I'm at page 1, paragraph 1 of my submission.
Yes.
My lord, I say that it is respectfully submitted that the principle of finality should not have application in relation to these current appeals, despite the fact the trials were conducted a number of years ago and the decisions reached both by jury verdict and on appeal. It's submitted there are two distinct questions which the court should ask itself in consideration of the principle of finality. My lord, I came across the case which I've included and is listed here of AIC Limited and the Federal Airports Authority of Nigeria, which is a 2020 authority which addresses respectfully this principle. In paragraph 2, my lord, the first question should be whether the application to reconsider a matter that is out of time should be entertained in principle. If the answer to that question is negative, then that would be an end to the matter. Of course, my lords, we say that it's respectfully urged upon the court that consideration is appropriate in principle, and it becomes an open-ended matter of discretion to be considered in accordance with the overriding objective. Coming back to it, my lord, of course, we say that what has occurred here is a fundamental issue as relates to this constitutional protection. His Lordship Coulson LJ, my lord, in the AIC case stated, in my view, the court should be looking for a sufficiently compelling reason that may justify reconsideration, something which might outweigh the importance of finality and justify the opening up of a question or questions which, following the pronouncement of the order in open court, appear to have been finally answered. Of course, it is quite right to say, as the authorities stress, that those categories of cases are not closed. But assuming that the request to reconsider comes from the parties and not the court should instinctively be looking for something which has been missed or otherwise gone awry. A mistake of a fundamental misapprehension, a fundamental piece of evidence, or a point of law that was overlooked. The undoubted jurisdiction to reconsider its earlier order cannot be permitted to become a gateway for a second round of wide-ranging debate. Your Lordships, we'll see the use of the word fundamental again, as ties in with his Lordship's ruling in the Trott case. And of course, my learned friend provided us with the case of the governor of Arbor Prisons. And I'll come to that in a while, but your Lordships will no doubt note in that case that the distinction that is made is that it was concluded that there would be application for a constitutional provision if there was some fundamental unfairness amounting to a denial of justice. So just dealing very briefly with that case that has been provided by the Crown, that is clearly the position on that. His Lordship's ruled, Chief Justice, that it was fundamental. Certainly in the case of AIC in dealing with finality, his Lordship Coulson there mentions fundamental pieces of evidence and fundamental pieces of law as well. So we would say that there is no question, it's beyond refute, that this is a fundamental issue, and therefore the issue with regard to finality is obviated. My Lord, I'm at paragraph 3 now. Counsel submits and invites the court to find that it can be nothing more egregious than the perception of inequality arms in jury selection that may have resulted in injustice because of an unfair or unreasonable approach by the prosecution, or the perception of that, my lords, in having more challenges than those permitted by the defendant, particularly if the perception of the reasonable observer is that the prosecution is jury stacking, which was the perception set out in evidence in Trott by an independent party observing the jury selection process. And that is also set out in Trott. My lords, remember in that case, there were 10 challenges that were made, and the observation was they appeared to be made in relation to a certain approach. Now, that wasn't the argument that was taken on the evidence. It was on the view of just what the Porter and McGill type of approach as to what the reasonable observer would do. But the reason that we took the approach, my lord, of having an affidavit filed was there happened to be an independent observer in the courtroom. He was a teacher with a group of students observing the proceedings, as often occurs in our courts. And that was the perception with regard to that case. And that is where the risk we
Sorry,
say.
is that, are you talking about Trott?
Yes, my lord. Yeah.
Yes, yes.
Yeah.
I see.
So,
Yeah.
But that's that, my lord. But the principle there is an overriding one, because Trott is made on the basis, and this is a significant point. Trott is made on the basis of what the perception was, not on the actual evidence in that case as to what it appeared to be, or on the evidence that it was 10 jurors stood by of Afro-Caribbean descent and so on and so forth, and appeared to be, or could appear to be the issue of jury stacking and the prosecution obtaining unfair advantage. It matters not, we say, if that can be the perception in any case, including all of these appeals. So the risk that there's been a miscarriage of justice, at former lords, or that there was an unbalanced jury selection and an advantage obtained by the prosecution that should not have existed, must respectfully outweigh the issue of the principle of finality. Counsel respectfully submits that the public interest and the significance of the constitutional issues raised in this case are capable in principle of outweighing any principle of finality, and they are indeed fundamental.
Can you just help me on this? The learned Chief Justice has held that the system that was in operation before the amending act gave rise to a reasonable observer would think that the Crown's ability to stand by many more than the accused could remove would indicate that there was a realistic possibility of bias. And you say, well, you're concerned at what the perception is, not whether there was actual bias. But there must be now hundreds of cases prior to the passing of the Act in which, in fact, the Crown has stood by, at the end of the day, more than 3 people. Is the upshot of these submissions, in effect, that in all of these cases, the appeal should be allowed and there should be a new trial?
My Lord, the answer has to be is we're dealing with respect with these 3 significant cases here, and we don't know. There may well have been, as your Lordship says, hundreds of cases since that time where there were more than 3 jurors stood by. One would hope that the degree of the conduct in that position with regard to the ability for the Crown to stand by, that fundamental principle wasn't respectfully abused in as many cases of that. But the fact of the matter is that we simply don't know. And one has to look at it, in my respectful view, with regard to the appeals that are before your Lordships. It could be the case. In Arbor, my Lord, their Lordship raised the decision that there must be tens of thousands of cases that occurred since that time. But again, they also made the point, and the constitutionality wouldn't apply to all of those tens of thousands of cases. But they do make the point that where it is a fundamental breach, that the constitutional provision should apply. So it may well be the case that there are that many. We don't know, my Lord, and one will, I regretfully submit, will have to cross that bridge when we come to it, and figure that out. But I would respectfully say, if your Lordships were to find that, as we urge, that this must be a fundamental issue, then we can't, with the greatest of respect, speculate on how many of those cases are out there for the sake of convenience as to how we have to deal with all of them.
But I hear what you say, but if it's a fundamental issue in this case, it's a fundamental issue in every case.
May well be, my Lord. If that challenge is taken in all of those cases, I mean, I agree. I think it would be a fundamental issue. If the fundamental principle applies here, it's going to apply across the board.
Absolutely. And that would appear to have the effect that in every case in which there has been a standby of more than 3, there has been a fundamental interference with the constitutional rights of the accused, and he is entitled to have the conviction set aside.
Yeah, my Lord, that may well be the case, and one can't obviate that with some colorful artifice, in my respectful view, by saying, no, it might apply to this case, it may apply to that case. It has to be that if your Lordship find that this is a fundamental provision, then the Constitution has application, and it has to flow out how it has to flow out with regard to those cases. And I just don't know what the answer to that can be, my Lord. I appreciate that it may raise an issue of concern, but the justice is blindfolded for a reason, in my respectful view, and that is part of the reason that has.
Well, this is indeed blindfold. But if one is considering which of 2 principles applies, the principle of finality or the principle of no appearance of bias, if one of the consequences of the latter principle applying is that hordes of previous trials and verdicts must be set aside, that might be a ground for saying that finality trumps appearance of bias.
It might be, my Lord, but with respect, that is why that the issue is what it is, and the law is what it is, and it would be unfortunate if in this jurisdiction, in that case, that the perception was that the Crown had the perception of abusing that principle for that many years, and regrettably that the government, the legislature missed it. I mean, I have to say, my lord, I said this from the beginning, having been a former attorney general here, we all missed it, with the greatest of respect. It was just, it went by through a number of attorney generals, through a number of court proceedings. I believe it may have been taken up on a couple of occasions and was given pretty short shrift. Not to sound a tautology, but it is what it is. The point was taken up when it was, and regrettably, it's not like it was something new. Because of the nature of the fundamental principle in the Constitution going back to 1968, it umbrellas all of that. It's the elephant in the room that was starkly there for all of those years, and the point was either taken and given short shrift, or was mentioned and given short shrift, or just wasn't taken up. And I say that, my lord, because I think it just became, if I may, a matter of bad habit. It was just a matter of bad habit. Many people, I think many of us didn't even look at the section when it came to jury selection. It was just accepted as a practice. Oh, it's 3 challenges. Had we really considered the section, we would have seen that since 1998 it was out of date, because it allowed for 5 challenges in what would have been a capital murder case, because before that time we had the death penalty.
Now, can you tell me how the Crown gets to 36? As I can't see the 36 in the statute. Well, haven't got to answer now, but the Crown has a right of standby of 36, but the number 36 doesn't appear in the statute.
I'll check it.
We'll check, my lord. I believe it's in the Jury Act. I think it's in the Jury Act, not in the.
Oh, is it? Oh.
Well, I'll follow up on that, my lord.
Yeah.
I didn't pull the number out of the air. I'm pretty sure we got it from
somewhere.
No,
you didn't. But I couldn't find where in the ground it was to be found.
We're looking for that now, my lord.
Yes. Don't let me interrupt you.
No, I'm obliged to.
If I might ask at this stage, Mr. Pettingill.
Yes, my lord.
For clarification, do you say that the very fact that the disparity exists in favor of the Crown is a basis for revisiting these cases, or is it in relation to how the disparity was exercised?
Exercised, my lord, into how the disparity was exercised. I mean, it existed as it did, but it's the exercise of it that is key to the consideration of lordship. And my Lord President, that may give some solace to opening Pandora's box, as it were, with regard to how many of those cases are out there, because it will be that it would have to be looked at as to how they were exercised. And indeed, we've had, some, and I will go through it again with regard to Brangman at some point in these proceedings, about how these standbys, stand downs occurred. And your lordship asked the relevant question that we'll come on to with regard to that approach, whether there was a de facto hearing, as it were, with regard to a standby or not. We say in Brangman there wasn't, but that may be a consideration in other cases. We're able to look at it and say, no, the standby, as it were, there was able to be viewed as being valid because the reasons that were given were so obvious. Oh yes, that's my brother that's in the box. Very, very obvious thing, which is captured in the new legislation, of course, because, and I just saw this recently, my lord, last week in assisting with a jury selection, happened to be in the new Trott case, that people can be stood by agreement, and it was quite a sensible course to see that unfold, that the Crown and defense were saying, yes, would agree to that. There wasn't the need to have a hearing. And that certainly shortened the process. And it was certainly fair, because there was both parties agreeing that a particular person should be excused.
But Mr. Pettingill, I don't understand why you're going through the excuse process, because there's no determination necessary if the Crown chooses to stand by a potential juror, is there?
No, that's right, my lord. There isn't. No. No, my lord, I was mentioning that as an aside because of what the legislation now does, which is.
So going back to my lord's question, if there are indeed hundreds of cases where the Crown did indeed exercise more than 3 standbys, is it not the case, on the basis of your argument, that each of those defendants would be entitled to have their conviction set aside and a new trial ordered?
Not necessarily.
I would say not necessarily, my lord. I think that each case would have to be viewed
Well, if
on.
it's a question of fact that there are indeed more than 3 standbys, you don't say that it necessarily follows.
I don't say it necessarily follows, my lord. It might be.
They might have been used.
So
They may not have been used.
yeah, they may not have been. They may not have been used. So it would depend on each case, as it has in this case, my lord. Everyone has had to be viewed.
I don't understand that may not have been used. If there's a standby, and assume that the jury is filled from the pool without having to go through the standbys again, doesn't that lead to an argument that there's inequality of arms if there are more than 3?
There is inequality.
It leads to that argument, yes, my lord.
Well, it doesn't really lead to it. It establishes it, doesn't it?
It establishes that argument, yes, my lord.
Yeah. So in every case in which either first time round or second time round, the Crown stands by more than 3 persons, there is a perception of bias. The accused has lost his fundamental right to a trial by a jury which is free from the perception of bias. And I can't think offhand what could be the grounds on your argument for not setting the conviction aside.
I would have to agree with that, my lord.
Yeah.
Other than I would say this, and this is it's encapsulated in the law now, but I have seen this, that there are circumstances where it may be that defense counsel, and this would be a question of fact on each case. Let's say it was a case involving a minimum number of challenges, say 5. It may be in some of those cases, and I know for a fact it has been, and one can see that this occurs, where there is a whisper in shell-like ear.
You use the word challenges. What do you mean by challenges?
I mean where there's an issue, where the Crown. I'll rephrase that. Thank you, my lord. Where there's a standby. Let's say there's a standby by agreement, and it could be that some of those cases involve that.
What do you mean by agreement? It's the Crown's right. The Crown exercises it. So where does the agreement come in?
Because, my lord, in some of those cases, and I can unequivocally state this to your lordship, I think the defense counsel, all of us have been there. It may be that it may be by agreement between prosecuting counsel and defense counsel that there is a issue is taken where defense counsel might say to prosecuting counsel, I know this juror, they're my next door neighbor, or they're my very good friend that I have dinner with regularly. Sorry, my lord?
So that would not be a prosecution standby.
No, but it may well, on a factual basis, my lord, it may not be, but it may well be that the Crown, on hearing that, stands that juror by.
Carrington argued this
and that would make a difference to the concern that your lordships are raising, and that occurs. And more to the point, my lord, I say that's probably sensibly why that was incorporated into the Amendment Act number 2, that standbys, stand-downs could occur by way of agreement, perhaps because of the size of the jurisdiction. But that is a sensible approach that has occurred. And
I'm sorry, that's that you can have it by agreement under the new statute.
Yeah.
We are concerned with the past. Take your example. Defense counsel whispers to the Crown counsel, he's my second cousin.
Yes.
Crown counsel then says, stand by.
Yes.
Is that a Crown standby or not?
Well, one would argue, my lord, that standby was not the Crown appearing to take advantage of its power to stack the jury, but that was by agreement between counsel, and therefore didn't impact on the fairness of the trial. And that would be a consideration in each, if there were there to be these appeals that would flow, there would have to be the analysis, in my view, that is being done here, where your lordships would have to consider what were the circumstances related to these standbys. And indeed, it's an exercise that your lordships have undertaken and are going to undertake in some in-depth analysis with regard to these appeals, because it may well be even here that that is a position that the relevance of what is the basis for the standby has to be considered. Right. So that is a factor that wouldn't necessarily amount to every standby being a standby if it was with the consent of the de facto defense. And there will be unquestionably, did you say argue at some point? There would be unquestionably issues of that. Where was that? Excuse me, Lord.
Mahoney argued it last time we were in front of this court.
Right. I think my learned friend, Mr. Mahoney, the last time that we were having this discussion actually raised that point, and he's quite right. I concur with it. That does occur, and has occurred, and probably occurred in any number of cases.
Standby by agreement, as it were, is not a Crown standby.
I agree, my lord. Yes, that's right. But that would be if there were to flow a number of appeals on the basis of the appearance, it would warrant an analysis of the record of the reasoning for the standby. And if it were that someone was stood by on the basis of agreement, or because of something that was brought to the attention of the Crown by the defense, or the Crown, and I've seen this as well, my lords, we all have, the Crown indicates to the defense counsel, oh, this person is my neighbor, is my cousin, is whoever, I have a close relationship with them, and gives an indication, not necessarily to the court, but to the defense, that this is the reason for the standby. And one obviously notes that this person was stood by for that, and it's not an issue.
Mr. Pettingill, in the November leave application, there was an instance when we were going through the standbys that Mr. Mahoney pointed out that in respect of a particular lady, he just said standby. And when he was addressing the court in November, he indicated that the reason for having done so was that the lady was an employee in the Human Resources Department of the DPP's office.
Yes, my lord.
Now, those matters were not shared with anybody. Mr. Mahoney simply said standby. So there is a good reason for the standby. It isn't shared with anyone. Does that make it a Crown standby that we have to take into account for the purposes of undertaking the exercise of determining inequality of arms?
Yes, my lord, it is, unequivocally, I would say. And it's something you would take into account as to whether you ordered a retrial. But I say this, that the system is designed in such a way that that particular example that your lordship gives, that person shouldn't have got on the panel. That's something that should occur before the panel is created. And so really, they shouldn't have been there.
But they were.
Yes, they were. But with the greatest respect, my lord, that's the Crown then shoots himself in the foot by putting that person on the panel and then using that as a standby. So if the defense doesn't know, the perception is you just had another challenge that I don't have. So that,
sorry, I don't quite understand what you have said. If there is good reason for a standby, but that is not shared by the Crown, is that a standby or not?
It is, my lord, yes.
It is.
In my view, unequivocally, yes. Because the fundamental principle here is about fairness. It's about what is in the mind of the defendant and what is in the mind of the reasonable observer. It's that test. So because one can go back and say, oh, well, I had a good reason for that. If at the time of the challenge, the reasonable observer, and this takes us down to Porter and McGill and those types of things, the reasonable observer doesn't know that, then it doesn't count. I mean,
Well, that's inconsistent. That's inconsistent, Mr. Pettinger, with the answer you gave to the situation which was posited earlier of defense counsel whispering to the Crown, such and such a person is my neighbor or my second cousin, which you referred to as a standby by agreement, which wouldn't count as a Crown standby. Now, the defendant might have been unaware of the whispering and certainly would be unaware of the reasons.
Well, with respect, my lord, again, all of these, the factual matrix of this shifts all the time, and it's with great respect, my lord, it's not inconsistent with what I said. It may be in that instance that the reasonable observer doesn't know, but he wouldn't be the one that was bringing the appeal. The defense counsel, the appellate, would be bringing the appeal, and the way that it should occur in those circumstances is two things. Two answers to that is: one, defense counsel should stand up and say to his client, the defendant, I know this person, they're my cousin, they can't be on the jury. I don't, and by the way, you're doing that on the basis you don't want to exercise one of your 3 challenges to get them off, but fairly, counsel has a duty to act fairly, so they shouldn't be on there. Now, it may be the case that counsel misses that and doesn't tell the defendant, but that would be a matter, obviously, of integrity of the bar, where defense counsel, on your lordship's analysis, would have to say, well, actually, on that one, I had indicated in representing the client that this was a person that should be stood by. So again, it would be an analysis of all of the facts to that. But those are 2 different scenarios, my lord, between the Crown standing somebody by and later coming along and saying, oh, that person works in the DPP's office. Now, had they leaned over the defense counsel and said, with respect, I'm standing this person by because they work in the DPP's office, that's certainly something that I think any counsel reasonably worth their salt would probably indicate to their client, this person's being stood by because they actually work in the DPP's office, and we, with respect, wouldn't want them anyway. So one would expect the honorable approach that Mr. Mahoney took in that case of saying, this is the reason that they're being stood by. But you've got to give notice of that if you want to, avoid a fundamental issue being raised later on.
This gets more and more complicated. There are at least 3 possible scenarios. One is that counsel sends a message to the prosecutor saying, this is my first cousin.
Yes.
The other is that counsel, the Crown, stands somebody by because he knows that she works or had worked in the DPP's office, but is silent on the topic. The third is that the person in question is called and the Crown says, stand by, I'm doing this because she works in the DPP's office. Now, in the latter example, is that a Crown standby or not?
No, that's not a Crown standby.
What is it?
Well, one would be for cause, my lord, in analysis of that scenario, that would be for cause. And also that would be something, that is shared between counsel. You're aware of the reason for the standby. So it doesn't create that appearance of bias that you're just doing it for some nefarious reason because you don't like the look of the person or because you're trying to establish a certain makeup of the jury and abusing the exercise of the Crown's right to have unlimited standbys. Right.
So if the Crown says she works in the DPP's office, I'm standing her by, that's a standby for, that's a stood down for cause, is it? Yes, or by agreement, yes. And that would, well, assume that the counsel is completely silent. Excusing somebody for cause is something that has to be done by the judge, doesn't it?
Yeah, that is problematic. But what one would say in those circumstances is the judge assents to that standby, because there is that discussion, and we see this in cases where the judge says, yes, okay, you're excused. That's the point I make, my lord, with regard to a short, sharp hearing. There's no need to go into an in-depth analysis of hearing as to why that juror should be removed. It's they work in the DPP's office. Yeah. End of story, very short hearing. So again, but the point, my lords, is that it requires and will require that type of analysis of each and every standby. Some of them may be valid and not count, and some may.
As a practical matter, though, it seems where the record doesn't reflect what you're in effect describing as a challenge for cause, it will show a standby by the Crown. How does one have an effective inquiry in those circumstances?
My lord, I think in those circumstances, what's going to happen, as has happened here, it's going to require evidence to be produced to address that. Yes. I mean, if the record reflects that being the position, it would be a matter of evidence. And one would hope in those circumstances, and this would be the case, that, you know, over the last number of years, let's say, the defense counsel were able to say, yes, I concur with that. But it would probably,
yes,
one would hope, but we're living on a hope here. I mean, all I am expressing to your lordship is that there are going to be, and there will be, scenarios where there has to be analysis of the basis for the standby. And it may well be that Mr. Mahoney, been here a long time, or other prosecutors, or the record will indicate, certainly counsel's record of note would indicate this is the reason for the standby. In some instances, my lords, I can assure you that it happens where counsel just tell the judge, we're standing this person by because they work in the DPP's office. And then the judge says yes, and defense counsel certainly says yes. That would be a particular reason that was valid. And
yeah, once it's clear on the record that happened, then
I'm sorry, my lord?
Once it's clear on the record that happened, then you have a basis for an inquiry.
Yes. Yeah, once it's clear on the record. And there are instances on the record. And we have in Brangwell, you can see, that's why I laid out, I'm going to come to it, but at some point during this hearing, where, you know, I have gone through every scenario of the standbys and why we say that it's 7.
So what is, when one goes through this analysis, what is the basic question that you are having to answer?
The basic question, my lord, is was the standby, was it exercised fairly and properly, and did it encapsulate the fundamental principle as enunciated in Trott by the learned Chief Justice, that to the fair-minded observer, there can be no question that the process of the selection was fair, and that it was appropriate, and that it involved a random selection.
So you have, right, so in relation to each standby, you have to ask yourself, the reasonable observer sitting in the court, seeing what has happened, would he have reason to think that there was some degree of bias in what was going on?
Well, my lord, he may, but it's the overall scenario that has to be looked at. And that comes back to the case in Trott, my lord, where there were 10 challenges. I was there, obviously, and made the application, and there was an affidavit in support. There was none of that discussion. The Crown took the position, for whatever reasons they had, of standing by 10 jurors, as is laid out in the judgment, of Afro-Caribbean descent in a row, effectively, 9 of whom I think were males, you know, under a certain age. It had a certain appearance. And most importantly, though, it had that appearance to the defendant. That's it's a double-edged test. It has to be what and how the operation appears to the defendant first, and then the consideration of the reasonable observer. So it may be the scenario, my lord, that there is a quiet whisper of agreement between counsel for the Crown, and the defendant. This person works in the DPP's office and they're being stood by. And the citizen at the back of the court that's come in to watch things going on doesn't have a clue as to why that's occurred. But he's not the one that's ultimately going to bring the appeal that the process was unfair, because we on the front line know that it was.
Well,
and in certain instances,
the question is what the reasonable observer would think.
Yes.
Yes.
But I'm sorry, this gets even more complicated. I'm not quite sure whether you're saying, in relation to each putative standby, the question is whether the fair-minded observer would think that him or her not coming on the jury was an indication of possible bias, or whether you're saying that. What is that? What you're saying?
No, with respect, my lord, it's the overall picture that would have to be considered. It's not just that in isolation. They're allowed three, and then there are the others as they unfold. And it's the overall picture as to what occurs. And that, as in this case, in these appeals, would require that type of analysis. It's not as simple as that. Now that would, I could see where that would cause your lordship's, concern as to how many hundreds of challenges there were, how many jury trials there had been where this exercise occurred. But it would require that overall picture of each case and the understanding of why a person was stood by, stood down, or excused.
So the question is, having a look at the overall picture, was there an appearance to the reasonable observer of bias?
Yes.
In the jury selection? Okay. Yes. But assume that at the end of the day, the Crown stands down 5 people. 3 of them it's entitled, well, 3 of them is the same number as the defense.
Yeah.
But assume that in relation to the 2, the Crown stands by 1 for what seems to be a perfectly good reason.
Yeah.
But because he says this person has a connection with somebody or other.
Yeah.
But in relation to the 5th, he's just stood by with no explanation.
Mm-hmm.
Does that 5th one make the whole thing unfair?
Yes. Yes.
It does.
And your lordship, Justice Bell raised that with respect in the previous hearing when we were seeking leave, because the numbers started getting argued, and your lordship said, if it doesn't matter if it's 4 or it's 54, right? The point is that once you go over the equality of arms principle, you're stuck with that. So if it's 1, it's 1. That could have tilted the balance like a grain of salt added to a scale. We don't know. So once you've breached that fundamental principle, where it appears that that's unfair, even if it's 1, and I come to this later in my submission, it's too many. Yeah, okay. So now you're 4. You can't say, oh, it was only
and
just
that
1.
You must follow, you say, is irrespective of whether or not there are any concerns, such as an attempt to stack the jury.
Yes. Yeah, it's a perception of that. It doesn't, that issue of stacking the jury. The position, my lord, on that is the concern, that if the Crown does this without valid reason and abuses the principles related to standby, that's the risk of the perception, that you're stacking.
Yes,
that was the evidence in trial.
But on your response to my Lord President's question, it really wouldn't matter what the perception is. As a result of the mathematical exercise, that extra challenge, that extra stand down would be sufficient in and of itself.
Well, it would be sufficient because it would then put it in the box of being fundamentally wrong, and it would put it in the box of the concern of the perception of appearance. One wouldn't have to get into the details of whether it was or it wasn't. Once you go over the line, you're over the line. And that leads down the road, in my respectful submission, I think in all of our submissions, automatically to the breach of the fundamental principles. Once equality of arms is breached, it's breached.
So Mr. Pettingill, if I understand you, in relation to the example of the potential juror who's an HR employee in the DPP's office, if the Crown says we stand by in respect of that juror because, and explains it, you say that would be excused for cause as opposed to standby.
Yes.
And if the Crown stands by for that reason but doesn't share the reason, you would say that's a Crown standby.
I would. Because of the perception to the defendant and to the reasonable observer. You have, if we don't have the knowledge, my lord, if the defendant doesn't have the knowledge, if the reasonable observer doesn't have the knowledge, but the second part of it, if the defendant doesn't have the knowledge as to why you're doing it, it's a standby, or, you know, for without cause.
That's why there's a procedure for cause.
Yeah, that exactly. That's why, my lord, that's why there is a procedure for cause.
Yes, I mean, you just use the phrase standby for cause. There's no such thing as a standby for cause. It's a standby, or there's an excuse for cause which involves a determination which has to be made by the judge.
Yes, my lord, and regrettably, these terms, as your lordship will have seen, have been interchanged by judges, by prosecutor, by defense counsel, myself included, by all of us. Have been, you know, changed when they really, your lordship's quite right. There's no basis for that, but your lordship will see. I called it a habit. It's been a bad habit, but as a matter of habit, these are
we have seen it. Yes.
I'm sorry, my lord.
We have seen it in the transcripts.
Yes.
Everybody uses the wrong phrase, and one of the difficulties may be that there may be a nod from the judge, but it's counsel who says stand down, which suggests an excuse for cause.
But with respect, I think it was your lordship that made the point that, again, that isn't, my phrasing, that isn't good. Your lordship made the point that if it's the prosecution that says stand by, to the observer, the defendants, it looks like the prosecutor's controlling the show, not the judge.
Yeah.
It should be at that point that it's the judge that intercedes, as in the recent case I was dealing with, and says, yes, that sounds like this juror should be excused. And that is a judicial function that should occur.
Yeah.
The habit that has happened, and it might be from a nod, but the habit that has occurred is for the prosecution to say stand by. And that respectfully is unacceptable, as we observe now. My lords, I'm obliged for that. I am actually, if your lordship wishes me to go on, your lordship's next question, my lord president, was at your second question, was the effect of section 5. And I deal with that briefly, if I may, at page 2, paragraph 6 of my submission.
Yes.
My lord, it's submitted that if there is any action in a previous trial which can be viewed as raising the issue of a breach of the right to a fair trial, I'll say a fundamental right, because that's on the basis of the law, enshrined within section 6 of the Bermuda Constitution, then a true construction of section 5 of the Criminal Code number 2 Amendment Act can have no application whatsoever. So that's a short answer with that regard. If the issue that arises on review of the previous case can be said to be unconstitutional, then it must be unconstitutional ab initio, and any subordinate legislation endeavoring to obviate the principle with a saving clause not allowing for challenge to a defendant's constitutional rights should have no application. My lord, I come on to make the point that, and I say this with greatest respect, not to mean to be offensive, but what the Crown presented to the learned judge when they were saying they were going to amend the law didn't include the section 5, because I'd like to think at that point, I may well have rose and said, if you're trying to include a saving provision, you're going to run into problems. I didn't have that opportunity because it wasn't mentioned, nor did the Chief Justice have that opportunity. And you'll see in the judgment from Trott, the Crown, in conceding the point, came along and said they intended to amend section 5192 in the way that they did. There was no mention of a saving provision. That suddenly came up apparently in the middle of the night during the House proceedings and was passed. Regrettably, nobody picked up on the constitutional issues that were going to run from that. And it flowed out the way that it did. And then when we saw it, of course, this created this concern. But I say this, my lord, to the point that there would have been no need for a section 5 unless there wasn't the observation that there'd been a fundamental breach. Now, we would say that that does not assist in curing the mischief at all, but it's an attempt to cure the mischief. But that section wouldn't have been there if there wouldn't have been the acknowledgement that these are fundamental constitutional issues. My Lord, your Lordship, third question with regard to constitutional inconsistency at paragraph 8 of my submission, I say that it's submitted that on a true construction, Section 5 endeavors to preclude reliance by the accused in such a case and consequently is entirely inconsistent with the accused's constitutional rights as indicated above. It is an attempt to obviate the fundamental principles of fairness.
Can we just go back into the actual words of this saving provision?
Yes, sir.
Because as I've understood the argument of the appellants as a whole, there are really 3 points. The code, sorry, the Amendment Act operates for the future in the sense
2 and 3.
that it says effectively that for all future trials, there isn't going to be a right of standby. And if what it's dealing with is the future, then ex hypothesi, it's not dealing with the past. And we're concerned with the past. That's what I understand to be argument number 1.
Yeah.
Argument number 2 is a matter of construction. The saving provision provides that the method of challenge of the jurors under the Principal Act before the coming into operation of this act is not invalidated by reason only of the amendment to Section 519.
Yeah.
And you say, well, it's not invalidated actually by the amendment to Section 519 at all.
It's a breach of the Constitution.
Not only, but sorry, it's not invalidated by the amendment. The reason why it is invalidated is it's contrary to the Constitution.
Right, yes, exactly. Absolutely.
So that doesn't work as a matter of construction.
Can't, no.
And lastly, as I understand it, coming to 2, accordingly, no conviction should be quashed solely on the ground that it resulted from a trial in which the Crown stood by more potential jurors. If that is to be regarded as meaning, well, if that means, as it does, no previous conviction prior to this act coming into force should be quashed solely on the grounds that it resulted from a trial where, in effect, more than 3 jurors were stood aside, that if that was effective, it simply denies the accused his constitutional rights.
Yes, right.
So you say for all three of those reasons, this doesn't work.
Absolutely. You can't. So what's happened is the government of the day has decided to, oh, look at this and see how egregious it is. It's unconstitutional, and for quite right reasons, but certainly for, I'm sure politically it wasn't a bad move either, concede the case. And then perhaps one could theorize what's occurred is that somebody's looked at it and said, oh goodness, much like your lordships are, we could open Pandora's box here because of this valid constitutional point that we've agreed to. Let's try and cure the mischief by adding this saving provision, overriding the constitutional provision. Can't work, with respect.
The problem is, of course, that if this argument be right, short of an amendment of the Constitution, there's no way of getting around it.
That's right. Well, that would require a convention, of course, my lord, but that's a matter to be considered by others in different places as to whether that needs to be cured. I think there's a number of things that need to be cured in our Constitution, but that may be one of them. But with the greatest respect, my lord, and I don't mean to be terse, it is what it is.
Yes.
But I mean, it really is. And,
yes.
And I don't think that one can obviate it with some colorable artifice and try and dress it up or try and fix it with a Section 5 saving provision, because it just doesn't work. It just can't work. It's not just, it's not the order of how things are with regard to constitutions and how our Constitution works. Nice try is the most that one could say, I would think. Shall I move on, my lord?
Yes.
Thank you.
Before you do, let me just engage you on 5.2 for a moment.
Mm-hmm.
In light of your earlier submissions, that in each of these cases, one would expect that there's an analysis of what really happened in the jury selection process. If that were so, and one were to interpret 5.2 as saying no more than that, the mere fact itself that the Crown stood by more potential jurors than the defense could have stood by is not a sufficient ground for setting aside the conviction. But if after analysis, it turns out that that is what happened without good cause, that the Crown in fact stood by more than 3, and even that extra 1 without good cause, that would be a proper basis for setting aside a conviction. Would this provision be necessarily offensive?
It would be a proper position to do it, my lord, but what I would say is that the provision just needs to come out because it's just unconstitutional on its face. So I would say with respect,
on that analysis which I just proposed, that
even on that analysis,
that it might be saying nothing more than that it ought not to be set aside solely on the ground that the Crown had that right to challenge, or did in fact challenge, but it leaves room for the analysis we had been discussing earlier.
What do you think we have?
Well, if they weren't actually used, it's a question of whether you order a retrial or not.
Yeah, I guess that would come down to the question of whether a retrial or not is ordered, my lord. But I think one has to start on the basis that Section 5, 1 or 2 just shouldn't be there. If the constitutional challenge is made, it's going to require that analysis in any event, whether there's a clause that indicates, as it does in subsection 2 or not, that analysis still has to occur.
Well, that is what really troubles me about the proposition, and that's why I asked the question at the very outset, whether the objectionality of the right is the very fact that it exists, that the disparity exists, or it is whether on the way in which it was exercised that is objectionable. Because if it is the latter, it seems to me we get to the basis for this analysis, in which event it cannot be said that the conviction is to be set aside solely on the ground that the Crown stood by more than the defense had the right to stand by.
Well, I think that's correct, my lord. I think we're in agreement that really this shows how in effect why this clause is not appropriate to be there and should be struck down.
Well, wait a minute. This depends what it means. And what my lord was putting to you. As I understand it, you accept that if the Crown originally stands by 10, but at the end of the day, when you've gone through the second process, taking out those who were excused by the judge or removed for cause or the like, if what you get to is 3, there's nothing wrong with the process.
Well, there's something wrong with the process, but it would not give rise to a retrial.
My lord, that again, there'll be something wrong with the process, but it wouldn't necessarily give rise to a retrial.
Well, I heard Mr. Lynch say that, Mr. Pettingill, but what is wrong with the process?
Well,
He needs to be clear as he is in the jury.
my lord, because the fact of the matter is that there shouldn't have been that many exercises of standbys. That's where the process falls down. That's what the English provisions are. You shouldn't have done that many.
Yeah.
I mean, that's the process.
Well, right. Let us assume that the process is wrong because it allows you more than 3 standbys. You accept, as I understand it, that if you start off with 10 standbys and end up with 3, you're not entitled to have the conviction set aside.
I think, my lord, if the circumstances be that, then that must be right. Yes.
Right.
Yeah.
Absolutely. And that's what I've understood you to be saying.
Right.
So when one looks at 2, one has to think about numbers. What I think my lord was suggesting in the example that I have been given is, accordingly, no conviction should be quashed solely on the ground that it resulted from a trial in which the Crown stood by more potential jurors than a defendant, i.e. the 10 were able to challenge without cause. And if it says that, that in one sense is true but uninteresting. The critical question is whether you ended up with 3. If you ended up with 4, the conviction would be quashed on that ground. And whatever Section 5.2 said, the fact that you started out with 10 would be past history.
Yep. Yes.
Yeah.
Yeah. Quite. Wouldn't matter.
So, I mean, 5.2, if it's to be interpreted as meaning no conviction shall be quashed solely on the grounds the Crown started off with 10, I say it is true but uninteresting, because the critical question is how many it ended up with.
That's quite, I agree with that, my lord, yes.
Yeah.
Yes, and I think it is, in a sense,
Redundant.
interesting, because at the end of the day, it would be objectionable if it were interpreted as admitting of the inquiry we have been discussing.
Yes. Yeah, I agree with that, my lord. Yeah.
Sorry, it would be objectionable if?
Because it admits of the inquiry that we all agree, it seems, should be undertaken.
Yes. Yeah.
So it's not
It would be
objectionable.
unobjectionable, my lord. Unobjectionable. Yeah.
Right. Mhm.
Yeah.
It adds nothing.
But it adds nothing, to your lordship's point. It simply adds nothing. It's redundant.
Why do you need it at all?
We don't need it.
Yeah.
Yeah, it was a nice try, but you don't need it.
That may well be so.
Yeah, it's
Hence
just
true but uninteresting. Yeah.
Yeah, it is true but uninteresting. It's superfluous to needs and to the requirements of the Crown, I think, is the
Right.
So, thank you, my lords. So, my lords, I am on question 4 of your lordship's question with regard to retrospective abrogation of rights. I had to, it was a bit of a tongue twister, my lord, with respect to reading that question. Read it a number of times to consider it, but
Say it
here-
slowly.
yeah, Phil, thank you, my lord. So at 9, I say, council submits there can be no question that section 5 amounts to a breach of the separation of powers because of its intention to be a retrospective abrogation of rights and is clearly directed specifically against defendants in particular criminal proceedings, i.e. those proceedings in which it can be shown that there was a clear inequality of arms and that the safeguards of the Constitution were in fact obviated. That's what they're endeavoring to design that to do, to get around that issue of fundamental breach, if you will. The Chief Justice in Jamaica Trott and the Queen, the constitutional challenge ruling clearly found the Crown, in having 10 challenges compared to 3 for the defendant, was unconstitutional and in breach of the equality of arms. At 11, this observation was embraced by the government and took immediate legislation action to modernize Criminal Code Section 519 to ensure there was equality of challenges as between the Crown and the defendant. It is apparent that after the Attorney General submitted the proposed amendments to the court, the addition of Section 5 was written into the bill before it was passed in both houses and assented to by the governor. That's just the facts of the way it went down, my lords. It is clear that by inclusion of Section 5, consideration was not given to the point that the addition to the proposed Criminal Code amendment was in fact unconstitutional, as the Section 6 protections should have been allowed to defendants in previous criminal proceedings and consequently amounted to a retrospective abrogation. By way of example, there's been a plethora of cases, my lord. I make the example of just cases that have been revisited with the onset of various scientific discoveries like DNA and all the rest of it. It would be, and there's been a lot of them, many of them, both in the US and in the UK, they have had to be addressed. It would be entirely unfair, unconstitutional had they not been. And I would say that no attempt by a section to obviate that provision could have saved it, or that development. At 14, my lords, any modern development in law, particularly one that recognizes a constitutional issue, must be capable in the interest of justice of having application to past cases, particularly if the matter was not raised or considered at the time. It is trite that Bermuda Constitution Order 1968 was in play at the time of the hearing of the cases in question. So the protection was there, it umbrellaed them, it just didn't happen and didn't occur. Even to the point, my lord, where I believe, not wishing evidence, but there was a case where the issue was raised on what we call a capital murder case under Section 519, where it was argued to the learned judge that the defendant should have 5 challenges. And in that one example, it was allowed, because even though we no longer have the death penalty, it was recognized there, but didn't go any further, and it wouldn't get taken up. So there's even that anomaly that during this whole process of time since 98, everyone who was charged with a murder case should have had a right technically to 5 challenges. It was the fact that there was no longer a death penalty that they got reduced to 3. So even that basis, took away a further constitutional position where at least they had those challenges beforehand and didn't have them going forward. My Lord, with regard to the key question, I think as your Lordship phrased it, or the key issues with regard to question 5, the test to determine the breach, and I'm at paragraph 15 of my submission. It's respectfully submitted that the test as to whether what happened at the previous trials were in fact contrary to the constitutional rights of the defendant should involve an analysis of whether or not the conduct of the prosecution in standing potential jurors by amounted to a challenge which effectively removed the potential juror from sitting on the panel. At A, my Lord, your question, it's submitted that if a juror was stood by and was not subsequently either 1, successfully challenged for cause in a proper hearing, or 2, excused under the provisions of the Jurors Act by the court, this would amount to effectively a removal of the jury from the panel by the prosecution. The only way in which the standby could have been academic on the basis of any reasonable given would be if there was a proper assessment of the reasons by the judge after a hearing. At page 5 of the record in Brangman, the selection process, the learned judge properly set out the test to be applied. I commended this to your Lordships before in the application for leave, but just briefly, his Lordship, Justice Grieve, stated in Brangman, 1, do you know the accused person or any of the witnesses or the relatives or associates in such a manner or to such a degree that you may not honestly, that is without bias or favor to any side, deliberate in this matter. On the basis of the law you shall hear, on the evidence you shall hear in the trial only. An entirely proper and right and fundamentally fair direction to the jury that when the standbys occurred, needed with respect to be acted upon by the judge. The decision to excuse the jury must be that, excuse the juror, must be that of the judge, not the prosecution by either the words stand down or stand by, or effectively making the decision on what they have heard that the juror should be removed. So by way of example, my lords, juror stands up, and it might be before the Crown decide that they're going to stand them by for any reason. The juror says, oh, I know one of the witnesses, Mr. Smith. And the Crown says, stand by. Not good enough. That is not good enough, certainly in accordance with the proper direction that his Lordship was given. Once that has occurred, there needs to be that proper analysis, not that the juror is excused and leaves because they say they know Mr. Smith or one of the witnesses.
And Mr. Pettingill, if the judge says stand down, which is misuse of words, but it's one that we see time and again. If the judge says stand down without actually going any further in terms of conducting the exercise to establish whether there is excuse for cause, that would not be a Crown standby.
Well, my lord, that again is a mixed bag with respect, because if the Crown says stand by, and that very specious reason is given, and the judge says stand down, he's really just
Sorry, what do you mean by specious reason?
Well, it's not a substantial reason just to say I know, juror, I know a witness, or something.
But if the judge then says stand down, does that not take it out of the realm of a Crown standby?
No, I would say not, my lord, with respect, because it's the prosecution that has controlled that. It's the prosecution that raised it, and to the reasonable observer, in my respectful view, would be the prosecution that causes it. So the prosecution effectively says stand by, and if the judge adds on, yes, stand down or stand down, Well, there's two things to that. One, he's endorsing what the prosecution has said, but two, he's certainly not conducting a proper analysis and hearing as to what he's laid out in his submissions. If it's that much of a brief point, I know witness 6. And
you're saying the judge should then ask why.
Yeah, of course. The judge is bound under the law, my lord, to do an analysis as to what is, and it's set out. Justice Greaves said it quite correctly, my lord, in my submission here, and I highlighted it with respect. He says, in such a manner or to such a degree. I've seen judges do this. Somebody might stand up sometimes and say, I know, Mr. Pettingill, or I know Mr. Mahoney. And the question becomes, well, how well? Do you have dinner with them? Like when was the last time you saw them? That type of analysis in order to measure, to be fair, the manner or the degree that warrants them being excused from sitting on the panel by the judge. Otherwise, it just becomes, if it's that terse, with respect, Justice Bell, where it's just the Crown says stand by because they hear a one-liner that has no substance to it, and the judge says then, okay, stand down, with respect, not good enough.
Well, I didn't have any substance to it. It's the judge taking a view on whether what the potential juror said is sufficient to excuse for cause.
I agree with that, my lord, but it warrant analysis, because what I would say to that the example we're giving wouldn't be sufficient. So in that instance, the judge is two things. The judge is getting it wrong. And one, it appears to the observer and to the defense that he's just supporting what the Crown wants to do. And I think it was your lordship that made that point. It was, in the previous hearing, that it can't be that it is the appearance is that it's the Crown that is, and I think, Justice, in one of the authorities, my lord, and certainly it was highlighted in Trott at paragraph 32.
32 of Trott?
Paragraph 32, my lord. I'll take you to it now because it's an important point to this. My lord, if I just briefly, because I think it is important, 32. In agreement with the view expressed by Stevenson, Jay, and Bain, the disparity between the accused persons and the Crown's right to challenge jurors did not give rise to and meets the test for appearance of bias as set out in Porter McGill. The Crown's right to standbys under section 512 of the code, and this is what I commend to your lordship, cannot be upheld because the Crown is allowed to have a greater role in fashioning the jury. And the example that we're talking about does just that. In contrast, the accused person's role in selecting his or her jury appears is thereby significantly diminished. A fair-minded and informed observer is likely to conclude that it was a real possibility that the jury may be biased as between the Crown and the accused person. Such a state of affairs offends the appearance of impartiality of the part of the jury, which is an essential element of the fundamental rights to fair hearing by an independent impartial court guaranteed by section 6.1 of the Constitution. So I come back to, my lords, if it is the appearance is, as it would be once the words standby are spoken, the Crown is controlling the show, they are in fact fashioning the outcome. And just because the judge says, yeah, okay, go ahead, stand down.
But in fact, the Chief Justice is looking at the traditional standby here.
Yes, my lord, yeah, he is, yes. But that's, I mean, that's what has occurred. The point is that it can't in any way, in my submission, have the appearance that the prosecution is somehow fashioning the outcome so that the deck is getting stacked the way they'd like it to be. It's an easy one just to say, oh, I know so-and-so, and to latch onto that because perhaps you don't like the look of the person, or you decide you don't want that person, or they may be, biased or whatever. It's just simply not enough.
Just to come back to an example we gave, what you've been discussing is the circumstance of the juror says, I know witness X, and the Crown says, stand by. That's not good enough.
No.
And you say it's not good enough if the Crown says, stand by, and the judge then says, stand down.
I do.
Because he's not conducting an inquiry.
Yes. He's just endorsing the Crown standby.
Yes.
which isn't good enough, with respect.
Right. But an earlier example that you gave was if counsel said, I'm standing this person down because she works for the DPP. And as I understood you to say, well, that would be okay because that would be for cause. And the judge would be taken to assent to it. There seems to be a discrepancy between the two approaches.
There is a subtlety there, my lord, but an important one, because the one of I just know somebody, as occurs all the time in Bermuda, is not sufficient. The extreme example of I work in the DPP's office, one would not be able sensibly to argue that that was a Crown standby when the learned judge said, okay, yeah, you have to stand down. One would anticipate that the defense counsel was sitting there nodding their head saying, yes, absolutely. It would be, with greatest respect, it would be a nonsense for someone to endeavor to challenge that as a standby, having heard the Crown disclose this person works in the DPP's chambers. Where it becomes problematic is if the person works in the DPP chambers and the Crown doesn't disclose it to the defense or to the court, and it just looks like another standby. So again, this would require an analysis of that type of standby. But I would respectfully suggest to your lordships that those types of, I'll call them short shrift standbys by agreement, by sensible agreement, be very few and far between. And to my earlier point, most of those people, as in that example, should have been vetted out before they went on the panel. So they really got through somehow, which is unacceptable. That's a different thing though. But that whole jury panel vetting, as set out in the Jury Act, is there for a reason. It's to look at individuals that are on the parliamentary register and so on, and see what their status is. So if they have, convictions or the like, or they're infirm, or they're with respect, deaf and dumb, or they don't speak English, all of these things occur before they even get to the panel stage. So somebody who works in the DPP's office shouldn't be on the panel. They get that far, and certainly it's sensible to have.
There's a critical question as to what question you ask in relation to each putative standby. It's possible that the question that you should ask is, looking at the thing as a whole, is it in reality a standby by the Crown? It's one possible question. Another possible question is, did the circumstances in which the putative juror came not to be on the jury give rise to, for a reasonable person, to a real appearance of bias? Is that the test?
My lord, I'm sorry. Forgive me, my lord. It became the audio became very garbled in your second.
Were the circumstances in which the putative juror came not to be on the jury such as to give rise, in the mind of a reasonable person, to a real apprehension of bias?
Yes, my lord.
You think that's a good question?
Yes.
Yeah.
That is a good question.
Right. Because that's what's behind everything. I mean, the difficulty is one can take endless examples, but assume somebody who says, I've got a medical appointment in 2 weeks' time. And the Crown says, stand by. So nobody goes through the exercise of saying, well, what time of day is it? And are you only going to be out for an hour or whatever? The Crown just decides to stand by. In circumstances where the juror could have been excused if the position was that he or she couldn't really stand on the jury because of his medical needs. But in that circumstance, the witness says, I've got a medical appointment, and the Crown says, stand by. Would a reasonable objective observer think that the fact that the candidate in question didn't come on the jury showed a real possibility of bias?
Yeah, my lord, yes, it doesn't, with respect, and it doesn't go far enough. And I'll give you, lordship, a further example of that because I saw it recently. It's like one juror, this is the danger with that. One juror says, oh, I've got a medical appointment, and there's no inquiry made as to it. And the Crown says, stand by. One, they're fashioning the outcome and they're making the determination. Yeah. And two, if they're allowed to leave, 4 or 5 more jurors is going to pop up and say, oh, I might have a medical appointment in 2 weeks. Or I'm going to have one now. And so that is the reason, coming back to it, that his lordship very clearly said in giving the direction to the jury that it has to be for a valid, cause or reason to such a degree, in such a manner or to such a degree. And I saw this the other day and eventually had to rise and query it because there was a person that came along very eloquently said, like, I don't feel I can sit in judgment of anyone. And it was by agreement, they were excused. Mr. Mahoney was there, the judge excused them. And then interestingly enough, my lords, throughout the rest of the selection, there were 3 or 4 more people. One woman put her hand up who'd been selected and said, oh, I don't feel I can sit in judgment of anyone either. And at that point, I rose to say I felt that it had to go further than that. And I think his lordship quite rightly on that case raised the issue about, well, what is your fundamental belief that you don't want to sit in judgment of anybody else? But it has to be more than just, I don't like it, because nobody particularly would like sitting in judgment of somebody else. Nobody probably really likes it. It's a duty. So, I'm a judge perhaps, but it just would open Pandora's box to not have more inquiry if one could simply say, the Crown hears, I've got a medical appointment in 3 weeks, and the Crown says, stand by, and off they go. Or even if the judge at that point says, okay, stand down then, it's prompted by the prosecution. The judge hasn't made enough of an inquiry, and it looks like the prosecution is fashioning the positions. I have no question with respect to my submission that would amount to a challenge, a stand by, stand down, instigated by the prosecution.
Right.
My lords, I think I'm at B of 5B, paragraph 15, my lord, in relation to your lordship's question 5. B, page 4. It's respectfully submitted that it does not matter with regard to the position in relation to a juror who was stood by the Crown, but who would or could have been removed from the panel for the cause or excused from sitting under the Jurors Act, section 15, if it is the prosecution, is the perception of the Crown controlling the process of who sits on the jury. So I think your lordship's question was, well, suppose it all comes out that they had a valid reason to be excused or whatever. It doesn't matter. If the appearance is that the Crown is somehow controlling it, one cannot then go behind that appearance and say, well, had it fleshed out, then it would have been all okay, and obviate it with respect in that manner. That becomes a colorful artifice. It has to be that the reasonable observer hears it, most importantly, the defendant hears it and understands and appreciates it. If that doesn't happen, then with respect, it infringes on the constitutional fairness and the fundamental right to that. My lords, at 16, counsel respectfully submits that the assessment must be made on the basis that it is the actual appearance and perception that must be considered in the interest of justice in the exercise of constitutional fairness. If the appearance is such that there was a disadvantage to the defendant or an unfair advantage to the Crown, it cannot be a matter that can reasonably be obviated by consideration that a juror would have been excused anyway, and consequently there is no miscarriage of justice. With respect, it cannot be a matter of an academic consideration in answer to your lordship's question about does it become academic. It is the view of counsel that in a position where a juror was stood by the first time round by the Crown on the basis of some concern, and the judge then properly assessed the facts related to the juror the second time around and excused him, this would be a proper exercise of the court's power and the prosecution's standby. Regrettably, what invariably has happened and happens often is that when the Crown says stand by, the juror leaves, and they don't come around again, and that doesn't frankly happen a lot. It's the power runs out, and there isn't these types of hearings on inquiry as to why should that juror be excused are not common, and not occur.
Mr. Pettinger, I don't understand your last sentence there, where you say after the judge has properly assessed the facts.
Yeah.
related to the juror the second time around and excuse them, this would be a proper exercise of the court's power and the prosecution standby. What does that mean?
Well, forgive me, my lord. What I'm effectively saying quite poorly there, because I'm mixing up that term of the standby again. The proper standby would be an issue is raised. I have a medical appointment, or I have. I'm sorry, Lord.
That's not a standby. The standby occurs when the prosecution stands by.
That would be a standby.
If there's a reason whereby the potential juror should be excused for cause, that's a different exercise.
Yes, my lord.
So I don't understand why you have the last 4 words in.
I'll remove them, my lord.
But I'm afraid there's now another complication. Let us another complication.
Yeah.
Let us assume that the juror is stood by, and when he comes round the second time, it's suggested that he should be excused for cause. And after an exchange of about 3 sentences, the judge says, well, I'm excusing you for cause. So it's the judge who does it,
Yes.
not after any thorough inquiry. Does that count as a standby by the Crown?
Well, again, my lord, depends on the circumstances, but I would say in those circumstances, again, it would depend on what the circumstances were. And it could be very short. It could be analysis of, yes, I can't, the initial standby could be because of employment or whatever. They come around again and they say,
work. My lord has given you the circumstances. Could you answer my lord president's question on that?
Well, my lord, with respect, my answer is it would depend on what the circumstances were. It could be that it's very short and valid. It could be short and valid. I work in the DPP's office. Okay, you're excused. The inquiry could be very short. And with respect, it doesn't mean
what happens if the judge either doesn't carry out a sufficient inquiry or simply makes a decision that's wrong? It can't count as a Crown standby if the judge has decided, can it?
I hate to say this, my lord, and let me try it, but it might. It might. It depends. I mean, I've given an example here where we discussed it a few minutes ago, where the Crown says stand by because the person says I've got a medical appointment, the judge excuses them. That would be something that's fashioned by the prosecution. And if it went round and the juror was stood by and then came back on and they said, I've got a medical appointment, and the judge just said, okay, you're excused, then that would, I would say, arguably be something that was prompted and fashioned by the Crown without a proper analysis, as his lordship indicated should take place. It may amount to arguably a prosecution standby.
Okay.
The difficulty here, and I don't envy your lordships this, as how one decides, to your lordship's question about what the determination has to be, is there's just a multitude, an absolute plethora of analysis that may be given as to what circumstances arise, and the only way to do that is by assessment of the circumstances at the time, and then the ultimate question has to be, did that appear to be fair? It becomes a question of degree in those circumstances.
My Lord President, if I may interject, I'm conscious that it's 11:07. Do you consider this convenient?
Yes. Shall we have a 10-minute break? Should we have a 10-minute break?
Yes.
Okay. Yes, my lord.
Thank you. See you in 10 minutes.
Thank you, my lord.
I'm gonna go look up.
Just a minute.
Joining the breakout room, Christopher.
Yeah.
Okay, we're back on.
Right. Mr. Pettingill,
Thank you, Mr. Quayler. Am I live?
you are live and in color.
Thank you. My Lord Justice President, you had asked just at the beginning with regard to the 36 number. And that was, as we had thought, is contained in section 13 of the Jurors Act.
Yeah.
At paragraphs A and B.
So it's not a limit on the number of standbys that he challenges, but it's,
Yeah. That being 36 names to comprise the panel of jurors for the session and 36 names to comprise standby jurors for the session. My lords, I'm nearly done. At paragraph 17, just to end that off, I submit that effectively a standby by the prosecution should in fact be the process of raising a flag of concern in relation to a particular juror, which can then be properly be determined by the learned judge. It should not be a mechanism for the prosecution to appear to effectively pick the jury that it wants. And my lord, I say this may be accomplished by agreement as legislated in the Amendment Number 2 Act at Section 3.1, which now appears to be the sensible process of issues where by agreement jurors can be stood by because of medical treatment overseas or so on and so forth. But again, that comes down to the appearance. My lord, with regard to the question 6 on question of retrial, I briefly say the following. It's my respectful view of counsel that if it is concluded there is a relevant discrepancy with regard to proper selection of a jury panel, then the Court of Appeal should set the conviction aside. Once the well of justice has been poisoned, even with a small drop, it is impossible, in my view, to then endeavor to safely draw the water again. There is no way to ascertain that a properly selected jury would not have come to a different conclusion had the prosecution, for whatever motivation or reasoning, appeared to have stacked the deck to give it an advantage. Most importantly, there is no way to cure the breach of the defendant's constitutional rights if his perception, and indeed that of a reasonable observer, is that the Crown had an unfair advantage or there was no equality of arms. This is the main point, my lord, is that the delay of time issues for retrial is also unreasonable in the circumstances, particularly as it pertains to Rangman. Counsel submits that given the fundamental constitutional nature of these challenges and the passage of time, in addition to publicity surrounding the various cases, if the court is minded to rule the process was in fact unfair, then in the circumstances, this significant issue on the balance outweighs the public interest of a retrial. I should, with respect, my lord, sensibly add to that the caveat that, again, it would become a question of consideration of degree. If it had been a trial that is being challenged that took place perhaps, 9 months ago or a year ago, that may be a valid consideration in the circumstances for retrial. If the trial was, 10, 11, 12 years ago, then that, in my respectful view, is a different consideration. My lords, unless I can be of any further assistance on these particular questions in your lordship's letter of March 1st, those are my submissions.
Mr. Pettingill, your reference to the jury pool having been poisoned, is that another way of saying that a conviction by an earlier jury being known to a subsequent jury might prevent there being a fair trial?
Yes, my lord, because I think the publicity point is a fair one. Many of these cases involve a high degree of publicity in a small community. The convictions would have been well publicized and well known, as with the facts as well. And it'd be very, very difficult then to turn around and ensure, if your lordships were to conclude that the well had been poisoned, it'd be very difficult to then somehow think you could drain the water and re-add it and have a properly constituted jury and a fair trial because of the delay. In my view, with respect, it'd be very difficult to justify that in accordance with section 6.1 with regard to fairness.
Okay. 6.1 of the
Constitution, Lord.
Constitution, yeah. Oh, I see. 6.1 of the Constitution, yes.
Yeah.
Yeah, yeah.
Right to fair trial, reasonable time.
Yes, yes. Yeah, yeah. Yes.
Unless I can be of further assistance at this point, my lords.
No, not at this point. Thank you. Yes, Mr. Lynch.
And over to Mr. Lynch.
Mr. Pettigill and I, as you lordships have heard, had an opportunity to discuss these matters in advance of making submissions before your lordships. So I don't propose to repeat that which he has said already, but I do and would like to address some of the issues that have been raised. I do so now. Can I start, please, with what might be regarded as one of the fundamental issues to be determined by your lordships in a case such as this? And that is really in answer to the very first question that's posed by the letter of the 1st of March from the court. And that is, now, is it too late to reopen the question as to whether the jury was not properly constituted? And does the principle of finality apply? And if I may say so, of course, during the course of argument with Mr. Pettingill, your lordships raised a number of issues arising from that question. And of course, it must be that there is a strong public policy in not reaching back from a decision made by a court that a particular provision is incompatible with the Constitution. It's one thing in one case where that argument is being made to determine that it is unconstitutional to proceed. The effect of that going backwards is a completely different matter, and I readily accept that before making submissions as to why in this case you should. In our submission, balanced against the public policy of not opening or allowing the reopening of floodgates, which it might be described as, I think my Lord President made the point that maybe it's 100 cases or more that might come back before these courts. The long and the short of it is that we don't necessarily know that. And perhaps even the analysis made so far in relation to these 3 cases before your lordships illustrate the fact that they are very different, merely because the words standby were uttered by the prosecutor doesn't necessarily follow that it would import the setting aside of the conviction and or ordering a retrial. Your lordships may have seen the case relied on by the Crown of the governor of the Arbor Hill prison, which I had first introduced at first instance and omitted the Supreme Court's decision, which overturned the first instance decision. It is an important case in our submission, and one which no doubt the court is gratified to have. In a 5 judgment case, the Chief Justice and the justices all gave reasons why the original overturning of the conviction should be reinstated. In short, what had happened in that case was that a little like the scenario we have here, there was a satellite case which determined that a particular provision of the Constitution was in breach of that Constitution. And in that particular case, what it was that there was potentially a defense of honest and genuine belief that a person of the age was a person who was at the age 16 when carnal knowledge between the defendant and that person occurred. that was excluded by statute, and that was held to be inconsistent with the Constitution. In that particular case, the defendant was himself only 16, and the victim was, I think, 15, and had honestly, and the defendant had honestly believed that she was 16 because she told him so, and there was no question about that. In the satellite case, which gave rise to the governor of Arbor Hoyle Prison, what had happened was the man in that case, charged with a similar offence, was 38. His own daughter was at the same school as the child that he had carnal knowledge of. And so there was no question that he could have possibly been, and I think she was 12. So there was no question of it possibly relying on the specific defence. And what he tried to do was to rely on the fact of a breach of the Constitution. And that is a very different situation, we would submit, from where we are here in this case. And it was recognised in that case that in the right circumstances, which we say these are, that public policy cannot be trumped by the need for ensuring the interests of justice are properly served. And can I take you, please, to, I trust that you've been provided with this. I know it's not on our list, but I think that it was uploaded by Mr. Coelho either yesterday or the day before. Have I got that right?
Was this the case that you sent on the Constitution?
No, this is the governor of Arbor Hill Prison sent by the Crown.
Yeah, that's in the authorities bundle.
Is it?
In the original authorities bundle or the subsequent?
I think it's in the original one.
It's at page 404.
Yeah.
That's 404. Just a moment.
Yeah.
Yeah, I'm not sure that that is the right one. Just a moment. No, it isn't 404. That was my authority, which was overturned.
Wait a moment. Well, 404 is the one that was overturned, but if you go to 425, you find the decision that overturned it.
Thank you. Can I take you, in that case, to 25? Yes, indeed, yes. Can I take you, in that case, to, no, I don't have the paragraph numbers that this one does. 16 of 42. I believe it's page 16 of 42 of the judgment, although they are completely differently paginated. And the bundle there has got paragraph numbers and mine does not. So if you will forgive me for a moment, I'll find the exact place. It's the end of Chief Justice. It's the end of Chief Justice Murray's decision, which is probably 10 or so pages through the judgment, under the subheading conclusion. Keep going.
There are the Irish reports pagination, Mr. Lynch, in the middle of the page. Shall we use those?
Mine doesn't have any. Mine, the only pagination my copy has, sadly, is the pagination that comes from Lexis, without any paragraph numbers.
Well, the conclusion is, I think, at page 448 of the bundle of authority.
I've got it, my Lord President, at 458. Paragraph 170.
Yes, conclusions is what I'm after, and that is contained at 448. Thank you, my Lord. 448, please.
Paragraph 122.
Paragraph 122. I'll mark that one here now. This is a decision from Chief Justice Murray in making a ruling in relation to the appeal that I've outlined. The fact that which I've outlined. And he trawls through, I hope that's not being offensive, he trawls through the jurisdictions both in India, in Canada, in the European courts and elsewhere, as well as Ireland, in seeking to understand the position in relation to finality, the question that your lordships posed in your paragraph 1.
Yes.
And he says this: in the light of the considerations outlined above, the judgments and dicta of this court to which I have referred, I am satisfied that the Constitution permits, if not requires, a distinction to be made between a declaration of invalidity and the retrospective effects of such a declaration on previous and finally decided cases.
Mm-hmm.
There are transcendent constitutional reasons why a declaration of constitutional invalidity as regards a statute should not in principle have retrospective effect so as to necessarily render void cases previously and finally decided and determined by the courts, which reasons include the interests of the common good, an ordered society, legal certainty, and the need to avoid the incoherence which would be brought to the system of justice envisaged by the Constitution if any other approach were adopted.
Mm.
That there encapsulates the rationale behind the principle of finality of which your lordships have referred. One can readily see the cogency of such an argument. He goes on a little further down the page under the general principle to say this: in a criminal prosecution, where the state relies in good faith on a statute in force at the time, and the accused does not seek to impugn the bringing or the conduct of the prosecution on any grounds that may in law be open to him or her, including the constitutionality of the statute, before the case reaches finality, on appeal or otherwise, then the final decision in the case must be deemed to be and remain lawful, notwithstanding any subsequent ruling that the statute or a provision of it is unconstitutional. That is the general principle with which it would be difficult in our respectful submission to disagree. However, we can in our submission distinguish, because here in that particular case, what they were dealing with was a statute which provided a defense which had been removed and was found to be unconstitutional, providing a defense to a criminal charge. Here, we're dealing with the very fundamentals of a trial, that is, that it should be fair and unbiased. That is quite a different matter from providing a particular defense in a particular case.
Can you just help me? You say they were dealing with a statute which provided a defense to a charge. What had happened? Had the statute been repealed and that repeal was unconstitutional?
Yes, the existence of the right to raise as a defense an honest belief had been removed.
I see. By statute.
Yes.
And the removal was unconstitutional.
Yes. Incompatible with the Constitution, yeah.
Yes.
Yes.
Right.
Recognizing that particularly in the sphere of criminal law, that there has to be, as always, within the vicissitudes of life, that there has to be an exception. He goes on to state this: I do not exclude, by way of an exception to the foregoing general principle, that the grounds upon which a court declares a statute to be unconstitutional or some other extreme feature of an individual case might require, for wholly exceptional reasons related to some fundamental unfairness amounting to a denial of justice, that verdicts in particular cases or a particular class of cases are not allowed to stand. And we would submit that we fall fairly and squarely within that recognition of the exception that exists within this authority. All four judges after the Chief Justice gave their reasons for agreeing with the decision But one thing is clear, is that they all agreed with these principles as outlined here. And in our submission, what we are faced with is a situation of an exception to the general principle as outlined there, because it strikes at a denial of justice in such a way that for these exceptional reasons, that is to say, a jury stacking exercise, which has resulted in a potential for a biased jury, that this should properly and can properly be considered. Can I, in seeking to make good on that submission, refer your lordships to our original skeleton argument, which we set out a number of reasons why the case should be reopened. And does your lordship have the what's headed as argument on appeal, dated the 15th of February?
Is it in the consolidated submissions bundle?
It is.
Which page?
It's at page 26.
Yes.
If your lordships go to paragraph 6, it's made in smaller print because it's a direct lift of our original submissions from last year. Does your lordship have that?
Yes.
Under the heading reopening of appeals.
Yes.
And then if your lordship would go, please, to paragraph 12. Because, and I mean, I commend all of the skeleton argument, but I don't want to take up time literally rehearsing what I've set out in that argument. But what is important is this, is that your lordships will see at paragraph 12 that in the United Kingdom and in our submission adopted here, there are civil procedure rules set out in Rule 52.3 that the Court of Appeal or the High Court will not reopen a final determination of any appeal. That is the basic rule of which the case of Arbor seeks to set out. What it does say, though, is unless it is necessary to do so in order to avoid real injustice, B, the circumstances are exceptional and make it appropriate to reopen the appeal, and C, there is no alternative effective remedy. In our respectful submission, what your lordships have here is a recognition of the need from time to time to break from the finality of any case where it is right to do so. That is encapsulated in this particular rule, in the civil procedure rules. And if it is good for the civil procedure, we would submit it must be doubly so in a criminal case where the liberty of the subject is at stake. We refer to the case thereafter of Yassin of 2015. So it is, you'll appreciate, some 9 or 10 years, 9 years, I believe, after the decision in the Irish courts of Arbor. And in that case, can I take you to paragraph 13 on the following page, page 7, which sets out the quotation that we rely on.
I'm so sorry.
So we're on page 7 of these submissions.
Yes.
At the top of the page is the quotation from the case, which is in fact that paragraph 27 in the authority at page 292, but I don't ask you to turn that up at this stage. And I simply rely on this passage. We must therefore address the issue as a matter of principle. In Taylor and Lawrence, as we've set out, the court based its decision on the implied or implicit power to do that which is necessary to achieve the objectives of an appellate court in circumstances where no express power was conferred on the court and its powers were exclusively based on statute. The way in which the civil division approached its power to reopen an appeal is grounded in clear principle. we can see no basis for any distinction between civil division and the criminal division as to the principles applicable to the jurisdiction under the implicit powers of an appellate court. The appellate jurisdiction of each is statutory. There is no reason why both do not have the same implicit jurisdiction and the same general basis for that jurisdiction. The fact that both have some implicit jurisdiction does not mean that the jurisdiction has necessarily to be exercised in the same way by the criminal division as it would be by the civil division. For example, in a criminal case, there will often be three interests that have to be considered: that of the state, that of the defendant, and that of the victim or alleged victim of crime, even though the victim is not a party to the proceedings under the common law approach. There is the strongest public interest in finality. The jurisdiction is probably confined to procedural errors, particularly as there are alternative remedies for fresh evidence cases through the Criminal Cases Review Commission. Well, of course, we don't have that in Bermuda.
No.
However, although we can decide this appeal in this way and make it clear that the court has an implicit jurisdiction on the same basis as the civil division, we consider that it would be appropriate if the Criminal Procedure Rule Committee can formulate a rule similar to that set out in the CPR, which delineates the factors and circumstances applicable to the criminal division. So that was a first recognition, if I can put it like that, of a breach, if that is the appropriate description, of the rule against finality or for finality. And so in our submission, what we have is, once we've established that a breach has taken place, are the circumstances in our case such as to justify a breach? And if your lordship goes to the next page, paragraph 15, we rely there on the case of Gohill, Banderesh, from 2018. And again, a short quote, which I commend to the court. On the footing upon which Yassin was decided, namely, there was no difference between the jurisdiction of the civil and of the criminal courts to reopen previous final determinations, it can safely be said that the criminal courts would not reopen a final determination of any appeal unless, one, it is necessary to do so in order to avoid real injustice. I pause there because in our submission, a potential biased jury is real injustice. Two, the circumstances are exceptional and make it appropriate to reopen the appeal. They are exceptional, where we can demonstrate, as no doubt we will seek to do next week at some stage, that the challenges that were, or the standbys that were put forward by the Crown were such as to make it exceptional. And second and thirdly, there is no alternative effective remedy, and there isn't, we would submit here. If the purpose of a court of appeal is to right wrongs, the recognition that this is a wrong should not be hampered in any way by a rule to finality, where it can be rectified and justice can prevail. Continuing the quote, though it not be interpreted as a statute, these form, in essence, what may be described as the necessary conditions for the exercise of the Yassin jurisdiction, and are almost invariably to be cumulatively satisfied if the jurisdiction is to be invoked. So one needs to put an and after each. However, we can caution that Yassin does not hold that satisfying the necessary conditions is sufficient for the exercise of the jurisdiction. On our reading of these authorities, the court retains a residual discretion to decline to reopen concluded decisions, even if the necessary conditions are satisfied. And of course, we wouldn't seek to gainsay that. It must be ultimately a matter for this court. However, our submission, as you will appreciate, both from what Mr. Pettingill has said and from the submissions that we've put in writing, that it cannot be more fundamental than that there should be a fair trial as a result of an unbiased tribunal. And it's hard to envisage something more fundamental than that. And then subsequently to setting out the procedure to be followed, bringing an application to reopen a decision of the Criminal Division of the Court of Appeal, the criminal procedure rules now set out. And then they set out, as you can see in that on that page, what the criminal procedure rules are in the United Kingdom. And in our submission, they reflect entirely what was said in Go Hill, Bangladesh. And then reference is made over the page to the application to the present appeal. And I've set out again the necessity to avoid real injustice, the exceptional circumstances that we say prevail here, and that there is no alternative effective remedy identified. And unless you want me to take you through those, I don't propose to do so, because we submit that they are here in writing, which we provided last year and have reiterated here in these submissions today.
Yes.
What we say is this, that in relation to your first question as to the rule, the principle of finality, it is an important principle that the court must recognize exists and ought to give it due weight. However, our submission is that that can never trump the fairness of a trial when it is as fundamental as it being an independent, impartial tribunal. It is difficult, as I've said, to envisage something that could be more fundamental. Turning, if I may, to your second question, what on its true construction is the effect of Section 5 of the Criminal Code Amendment Act? How does it apply, if at all, to the case concluded before it is enacted, in which there was a disparity between the number of standbys exercised by the Crown and the number of peremptory challenges afforded to the accused, which you characterized as the relevant disparity? It's our submission, the short answer to that is that the Criminal Code Amendment Act is irrelevant to the principal issue of whether the defendant's constitutional rights have been breached. And as I think your lordship pointed out earlier in argument with Mr. Pettingill, and as I've set out in our paragraph 4, subsection 5 is irrelevant as to those considerations. The method of the challenge of jurors is not invalidated by reason only of the amendment. The method of challenge of jury challenge is invalidated because it was a breach of the Constitution. And really, section 5, subsection 1, is no more than a recognition of that fact. Section 5, subsection 5(2) in particular cannot stand, we would submit, as it is unconstitutional in itself. What the section purports to do is to remove a remedy that would otherwise be open to the Court of Appeal, to you, in circumstances where, 1, you accept the Constitution was breached, 2, that a particular defendant was convicted, and 3, that that conviction was as a result of an unfair trial. And yet the court cannot quash the conviction and, in the right circumstances, order a retrial. That simply, in our submission, cannot be right. And I come back to
that.
Yes.
Does section 5(2) really purport to go that far?
Well, on one reading, it might. I mean, I of course was mindful of the submission that Mr. Pettingill made in answer to your lordship's question about how one might read subsection 5(2). But it does, in a sense, depend on how one reads it. But in our submission, if it is intended to go as far as it could be read, then that would be wrong. And beyond that, if the rule to finality that we've just examined is the basic principle, then what does it add? In our submission, it adds nothing at all to the position. If you can't go back, then the rule against finality.
One interpretation, it might be simply seen as a statutory expression of the rule.
Well, I suppose you could argue, I mean, I think that it's certainly open to make that assertion, a statutory expression of the rule, but in a way, in our submission, you cannot have a section which seeks to remove from the Court of Appeal its right, and I'll come to it when we deal with separation of powers in a moment, but it's right to be able to remedy a wrong.
Right, so it would be that construction of it that you would say invalidates it.
Yes.
Thank you.
Your third question is, if on its true construction, Section 5 precludes reliance by the accused in such a case, is that inconsistent with the accused's constitutional rights? And we submit yes, for the reasons we've just given. Can I, though, move, which I think might be more helpful, to subsection 4 of your letter? Was Section 5, if otherwise effective, to preclude a challenge on the grounds of the relevant disparity, a breach of the separation of powers, because it was retrospective abrogation of rights directed specifically against defendants in a particular criminal proceedings? Our answer to that question, in short, is yes. Can I take you, I hope you'll have been given the case of Robinson, which I passed to Mr. Coelho yesterday morning. A Court of Appeal decision.
Which
Mr. Coelho, this was...
Yes, this was the case where you were supposed to provide a brief paragraph to explain.
I was going to add a paragraph, but it seemed to me odious in the light of what was already said. But yes, the case is Robinson.
Right, that was forwarded, my lord.
So
By email.
Begins with 30 of the supplemental bond of authorities.
Was that served on the Crown?
Yes, by email. I sent it to you yesterday.
Justice Melly, you said something, but I didn't catch it.
Yes, it begins at page 130 of the supplemental bundle of authorities.
Thank you, my lord.
Just a moment. I think we lost the supplemental bundle. Just hold the line for a moment.
Yes.
I'm sorry, Counsel, but I didn't receive any email from you or Ms. Tucker yesterday.
Sorry, is this case called Robinson?
It is, my lord, yes.
I mean, I got a supplemental bundle today which has Bestel, Ruddock, and Grant.
Don't know that.
I thought you said Washington, not Washington.
Yes, hello.
I've just sent it again.
Oh,
right. Thank you.
And Mr. Mahoney, I've also sent it to you, so check your email.
Thank you.
yeah. It's Washington that's in the bond, not Robinson.
Yes, and I sent it to Mr. Coelho yesterday at 1:42, together with my learned friends. I don't know why I didn't get it.
Well, I wonder what, I mean, it hasn't arrived in my inbox. And I see we have been sitting for 3 hours. I wonder whether now might be a time to break. Would that be convenient, or?
It's certainly convenient for me, and I apologize that you haven't been given this.
Well, no, okay. Well, we'll resume in an hour's time.
Thank you.
Thank you.
Mr. Coelho, I'll send it to you again.
No need. I've already sent it.
All right, thank you.
Counsel, you did send it to your other colleagues, but the Crown didn't get it. Wasn't included.
Oh, I'm sorry about that. I'll make sure you get it now.
I have a copy from Mr. Coelho.
Coelho, I haven't got a copy. It hasn't arrived.
I sent it just now, but I also sent it yesterday at 12:04 p.m. Bermuda time, so that would have been 4:04 p.m. yours.
Well, can we go into a breakout room, please?
Don't seem to have Justice Smelly. Yes, Mr. Quayle at the Court of Appeal. Could you have
We're good, right? Yeah.
Hey, the waiting for us all, you know. The waiting for us, you know.
We seem to be missing 2 appellants and 1 judge.
Yes, I've sent a message to the one judge. Let me just pop over into the meeting room to see if he's there.
We're now missing 3 appellants.
So they went home.
Okay, Justice Smelly should be coming over shortly. I see Mr. Roberts and Mr. Smith-Williams. I don't see Mr. Brangman.
Yeah.
Pardon me, my lords. Mr. Brangman is currently engaged in the bathroom. He should. There he is, right there.
Right behind you. We still seem to be one judge less. Just a second. Okay, and here is Justice Smelly.
Right. Yes, Mr. Lynch. Have we got all we have got all the appellants? Yes, we have. Yes?
Were you able to retrieve the case of Robinson?
Yes, thank you. Yes.
It's your question 4, if I can bring us up to speed, I was about to deal with,
Yes.
is you were dealing there with if Section 5, if otherwise effective to preclude a challenge on the grounds of relevant disparity, a breach of the separation of powers because it was retrospective abrogation of rights directed specifically against defendants in a particular proceedings. And I mean, this is an issue which, again, is of some importance, and we submit that it impacts, of course, on the remedies that you have available to you should you find that this was a case that was in breach of these defendants' constitutional rights. In the case of Robinson, your lordships may recall that this was a case which dealt with the sentencing regime for murder simpliciter, for want of a better expression, and murder with intent to kill, where the minimum term of imprisonment was stated in statute to be 15 and 25 years respectively, and fixed irrespective of the circumstances of the offence. As a result, that was taken to the and in the Court of Appeal, the President set out the reasons why he found that that was a breach of the Constitution. It is useful in that it deals with the question that you've raised in your question 4. Can I take you, please, straight away to page 8 of that judgment at paragraph 13. And there it sets out, in Anderson's case, however, the House of Lords held that the power to fix the minimum period that the prisoner must serve is a judicial function, which should only be exercised by an impartial tribunal. And this followed the decision of the European Court in Stafford in the United Kingdom. The so-called tariff period is the appropriate punishment for the individual offences committed. Turning to paragraph 14, interpreting section 2881, which was the one that was challenged as being a breach of the Constitution, as amended against this background, it is immediately apparent that the legislature recognized 3 things. First, that the sentence of life imprisonment will not necessarily be served in full, nor is it indeed that it shall be, nor is it intended that it shall be. Secondly, the question of early release becomes in due course a matter for the parole board. And thirdly, that a minimum period of detention must be served as the appropriate punishment for the crime that has been committed. And then the subsection goes further by specifying the minimum period which the legislature intends shall be served in every case. Skipping a few lines, in short, it is the legislature which has fixed the tariff period in all such cases, possibly for every case, not the judge or other judicial body. And then he goes on to analyze that. If you go over the page, top of the page, the issue which arises is whether the legislature is constitutionally entitled to impose that restriction in every case. And then following a short quote, paragraph 17, it follows from this that where the legislature itself has prescribed the tariff period, the minimum applies, that minimum applies in all cases, regardless of the circumstances of the individual case. Yet it is now well settled and equally uncontroversial that determining the minimum period is part of the sentencing process and a judicial function. At paragraph 18, the remaining question is whether the legislature can specify the minimum period, notwithstanding the fact that they were notwithstanding the fact that were the task delegated to others, it would be a judicial function, which only a judicial authority could perform. Whilst the legislature can determine what conduct is to be regarded as criminal and what sentences may be passed for each offence. The legislature cannot act ad in hominem, nor can it determine the sentence shall be passed in individual cases. The underlying principle was discussed in the judgment of the Privy Council in Forrester Bow and Trono Davis and the Queen in 2006, which was concerned primarily with the clear line of demarcation between the power and authority of the judiciary and the power and authority of the executive, per Lord Bingham, but which also referred to the question of whether judicial power was intended to be shared with the legislature and the clear distinction between the prescription of a fixed penalty and the selection of a penalty for a particular case. And then skipping a few lines, we therefore hold that Section 288 is unconstitutional insofar as it purports to impose a minimum tariff period of 15 years for all cases of murder, regardless of the circumstances of the individual case and offender. We submit that the position here is similar in that it is not for the legislature to remove the one feature that the Court of Appeal, or one of the features that the Court of Appeal can exercise in its judicial function. That is to say, that the decision as to whether or not to set aside a conviction. The Appeal Act injuncts the Court of Appeal to set it aside once it satisfies the criteria set out in the section 17, I believe. And it is in our submission that it is not for the legislature to remove from the court the power to say, in effect, that this conviction cannot stand and must be set aside. So, whereas it would appear that subsection 5 purports, at least, insofar as it does, we would submit that it cannot be constitutional. That, I hope, deals with the question that was raised as to whether or not there is a breach of the separation of powers, which we submit there is. Paragraph 5, which has been something which has exercised the court and the learned friend Mr. Pettingill in answer to questions, deals essentially with the question of the procedure to be adopted. But I wonder if I can approach it in this way. Standbys, one might suppose, were originally identified as a proper basis for the Crown to be able to stand a particular juror aside without having to discuss or enter into the issue of cause. That they could stand them aside, they go to the back of the queue, and should they be called upon again, there can be then an argument in relation to cause. That process has been, I hesitate to use the expression abused, but it has seemingly become the trend to use it effectively as a challenge by way of peremptory challenge, in the same way as the defense have 3 peremptory challenges, because they're very often put to the back of the queue and then there is no further inquiry. More importantly, there is often the case where they are stood down, I should say stand by, says the prosecution, and there's no inquiry. They're just put to one side. And that, in our submission, is obviously at the crux of the problem. And a practice has developed which has, in effect, aligned standby with stand down. It is allowed the odd sotto voce between defense and prosecution, where they felt that it was better to get the Crown to use their unlimited number of standbys rather than the defense having to use one of their few peremptory challenges. And very often the judge has seen on a number of the transcripts that we've examined, and in other cases, I've no doubt, by the experience of those practitioners here, that he simply endorses from time to time the application, if that's the right expression, to stand by, so that we're left with something of a morass as to exactly what it is that is happening in each case. Our submission is that what the case of Trott sought to do, and indeed the legislation seeks to do, is to regularize the position. Whatever the initial intention might have been for standbys, it has long stopped being that and has become effectively a peremptory challenge in the hands of the Crown. And this is intended to level the playing field in such a way as to make it fair for both sides.
Should be used exclusively.
Your questions, specifically, if I can refer to them, if the procedure under the unamended section was potentially contrary to the appellant's constitutional rights, what is the test in determining whether that happened was in fact contrary to those rights? And before I postulate what that test should be, you asked the question, as to this, do you have to ask how many potential jurors the Crown stood by who were not subsequently either successfully challenged for cause or two, excused under the Juries Act or otherwise by the court? I pause there. In our submission, the answer to the first one is yes, as is the second, but it is not quite as simple as that, because the test that we submit ought to be applied is what happened such that the casual observer is left with the impression that the jury is being rigged or stacked in favor of the Crown. It is not a case of each potential juror. It is the whole process overall that we submit leaves the casual observer to conclude that there has been a rigging or potential rigging of the jury stacked in favor of the Crown.
Well, just help me on that.
Certainly.
Assume that there are 10 standbys to begin with.
Yes.
And it ends up second time round with 4. And 6 of the standbys are validly challenged for cause or excused under the Jurors Act. You then got a circumstance in which there's, as it were, one offending standby left.
Yes.
If the question is what happened such that the casual observer is left with the impression that the jury is being stacked by the Crown, what is the answer to my question? Well, what is the answer to that question if there is only one more standby at the end of the day than 3?
Then it's a breach of his constitutional right to have a fair tribunal. It is also not an equality of arms as between the parties. What we have here is this, isn't it? Is that statute has recognized that 3 peremptory challenges for the defense, and now recognized as 3 peremptory challenges for the Crown in an ordinary case, does not leave one with the impression of any stacking. There has to be a line drawn somewhere. The line is drawn at 3 in a regular case and 5 in a capital case where life imprisonment is at risk. And it is for Parliament to determine what the proper line is. And where that line has been blurred as it was previously, the court has decided that that was a breach of the Constitution because it must be equal. And that equality takes away any impression that might be given to the casual observer identifying a potential rigging by one side or the other. And if Parliament has determined that 3 is acceptable, but anything more than 3 is not, then in our submission, that prima facie raises the answer to the question as yes.
I see that, but I'm not sure whether, I thought you said a moment ago, one has to look at the position as a whole.
Yes.
But in fact, in the example given, you only have to look at one of the standbys.
No, with respect, no, because you're looking at all four. You're saying, aren't you, in effect, that if in the hands of the Crown there are 3 challenges for no reason, just peremptory challenges, that is recognized as being at least on the right side of the dividing line.
Right.
It's not that that specific one that takes it over changes the perception. It's the fact that there are 4
I see.
overall. And if I may say so, it's not for us to sort of second guess what the casual observer might think, beyond identifying what Parliament has said is the limit. Parliament might have done, like they have done in the United Kingdom, done away with it altogether for the defence. And it is, as a matter of practice, now extremely rare for the Crown to stand by anybody in the United Kingdom. It's nearly always for cause. So the practice that has developed in the United Kingdom following changes to the legislation is to say, no, we're not going to allow any peremptory challenges on either side, effectively. In this jurisdiction, it's been determined that 3 is the proper demarcation in an ordinary jury trial.
So you look at the position as a whole in the sense that you work out what the ultimate number was. And if you get anything above 3, that's fatal.
Yes, yes, it has to be. I mean, otherwise, what's the point of having a line? If you step over the line, it becomes fatal. There are other considerations that the court may seek to apply. I don't seek to advance any of them, and maybe in the hands of Mr. Mahoney, there'll be other considerations that they will invite you to consider. But our position is that once that line is crossed, we impute into the casual observer the very criteria which we suggest creates bias, in the same way as if a judge has some feature about his history with any of the participants in a trial, you impute a bias. No one's suggesting actual bias, but merely that it is imputed in the court because of his connection with one side or the other, or some interest in the outcome.
Well, it's the appearance. It's the appearance of bias.
It's the appearance, exactly. It's the appearance. And so here we submit that the appearance is created by the statutory line drawn.
Yes.
So having said that, the little b, can I turn to that, please, of your questions? What is the position in relation to a juror who was stood by the Crown, by the Crown, but who would or could have been removed for cause or excused from sitting under the Juries Act? Well, in our submission, that is irrelevant. It is irrelevant because it didn't happen. If a juror is capable of being stood by for cause, that needs to be properly litigated in the way in which the Juries Act envisages. That is to say, either the Crown or the defence will say, stand by for cause, or I object for cause.
Mr. Lynch, can we use excused for cause and stand?
Yeah, forgive me, yes. Excused for cause. I raise it because, of course, it's not for the advocate to excuse for cause, but to apply for the particular juror to be excused for cause. And of course, it is always a matter for the judge, in the exercise of his discretion, how he deals with it. He may take the view, for example, a juror comes along, I've got a letter showing that I'm not very well and that I might have to be visiting the doctor on a regular basis. And the judge may say, I've got this letter. He normally would not give the detail of what's contained in it. It's about the health of this particular juror who may have to, on regular occasions, visit their doctor, and that might be disruptive for the purpose of the trial. I'm minded to excuse this juror. And anybody can say, well, no, let's have a little bit more about that. If we have to rise occasionally, that's not a big deal. Or they would just assent. That's the process through which each of these excuses should be governed. And the failure to adhere to that process is part of the difficulty that we've seen, because all too often what happens is someone might say, oh, not someone, the Crown say, stand by. The judge, and he may add a rider to that. He may say, known to the defense, to the defense. We think known to the defense, or something like that. And the judge assents for those purposes at the moment, says nothing. Nobody else says anything, and it becomes a standby. And that is what is objectionable. If it is for cause, state it's for cause. And in our view, standbys by the Crown should be used sparingly, even with the current legislation. It should be used sparingly. It's not an opportunity for the Crown to say, well, I don't like the look of that particular juror. Let's see if we can get rid of them, but for no reason at all, other than that it's a young man and we've got a young man in the dock. They shouldn't be doing that. That I appreciate is a slightly separate point, but it does seem to us that there is, on its face at least, what appears to be a deliberate rigging of juries by the Crown. Not in every case, of course not, but in some cases, and in these in particular, perhaps, that it is objectionable. And that's what causes the individual casual observer to stand back and say, well, if you're doing that many times, even if later on they come back, if it looks like every time that the prosecutor says stand by, and each time it happens to be a young black man and there's a young black man in the dock, it creates that sense of unfairness and bias. All right. Little c, what is the position in relation to a juror who is stood by first time round by the Crown and second time round by the judge? Well, can I say I'm not quite clear about, again, once the language being used, because if the judge doesn't have the power to stand anybody by, he has the power to discharge a juror following any application for cause. Or of his own volition in the right circumstances.
Excuse the juror.
Excuse, yes, forgive me, excuse the juror. And of course he can excuse the juror for a good cause or of his own volition if he thought there was circumstances which warranted it. And so it's never a case of the judge standing by. And part of the problem again has been that often the judge is seen to effectively ratify a standby by the Crown, where there is no ratification of a standby. It doesn't require it. It may be confused occasionally with a judge who might say, in answer to a potential juror saying, well, look, it's going to be really inconvenient for my employer if I'm not there because I'm the only person who knows how to operate Zoom, and we have a lot of Zoom meetings. And as a consequence, the judge say, well, I don't regard that as a particularly strong excuse, but I'll reserve my position on that. Stand over there while we call the next one. And that happens from time to time, and probably oughtn't to. But that is, I'm afraid, again, a scenario that all too often raises its head without objection. And perhaps we need
to... So if the judge does that sort of de facto standing by, that's not a Crown standby.
It's not a Crown standby unless the Crown in the first instance had said stand by. The Crown says stand by and then judge says, well, why? Because we're running out of jurors and he's getting a bit nervous that we won't have enough for the trial, as happens again. He says, why? And they said, well, the juror says, well, I'm the only Zoom operator. Then it may be that, as I say, he is de facto standing in by. But it may come back and ought to come back because that person, whether that is taking place or not, ought to go to the end of the queue.
What happens? This is probably a rather ludicrous example. Assume that the prosecutor stands by 7, and each time he does so, he smiles at defense counsel and says, do you mind if I stand by this chap? And counsel says, no, that's fine.
Still seem to be in collusion then.
Well, I won't. What I say to that is this: is if the prosecutor says stand by 7 times and the defense counsel says okay, fine each time, is that acceptance or of some cause? I would submit no. A standby is a standby. The only person who can is the Crown. Neither judge nor defendant counsel can do that. It is a power vested in the prosecutor alone.
Yes, I followed that. But the reason for my example is that if the prosecutor says to counsel, you haven't got any powers, well, you've only got 3 powers of the equivalent of standby. I want to be helpful to you. I'm going to stand by X, Y, Z, A, B, and C. And each time he says, are you happy with that? And counsel says, yes.
You're fashioning it.
The idea that that would create the appearance of bias when it's done with the consent of the express consent of the defendant appears counterintuitive.
Yes, and I wouldn't seek to dissuade you from that course, but isn't that a matter of evidence?
Yes.
If in fact, let us say that there were in this case, one of the defendants had 10 standbys from the Crown, but in fact there was evidence that you were satisfied of that 7 of those 10 were with assent from the defense. That might, whilst on the one hand, in our submission, on the one hand, that would still nonetheless be a breach of the relevant disparity as identified, the expression identified by you, would be a breach. In our submission, it would not necessarily in those circumstances give rise to the consequence of setting the conviction aside. So whilst you might recognize, well, that is a breach and it shouldn't happen in those circumstances, it shouldn't happen because other counsel come along representing this defendant and say, well, that previous counsel should never have done that. It didn't do it with the authority of the client. It didn't do it. It might nonetheless impact on the decision that you might make as to whether or not it would give rise to a proper basis upon which to say the conviction should be set aside and or whether there should be a retrial. So, and that would be a factual, that would be evidence being called by one side or the other, or evidence laid before, it might be on a transcript, I suppose, but it would be evidence upon which you would then be able to rely in deciding on whether or not what the consequences of that relevant disparity was in that particular case.
I think where we've got to is this. You look at the position as a whole, prima facie, once you get above 3 standbys to 4, that's to be regarded as giving the appearance of bias.
Yes.
But there may be some circumstances in which the appearance of bias doesn't arise in relation to the 4th person. For instance, if his counsel consented.
Yes, I think that's right. I certainly wouldn't seek to argue against that. I think if in those circumstances counsel did assent to it, it'd be very difficult to say, wouldn't it? In that would automatically give rise to setting the verdict aside.
Yeah.
And ordering a retrial. Of course it would. And that's I suppose what we are getting at in our last point when you ask in your question, should there be a retrial, and the previous question as to whether or not the conviction should be set aside. These are all factors that feed into those issues, are they not? And that's why I don't say that it is automatic that in the event that you found that there was a relevant disparity, that it would necessarily automatically lead to the conviction being set aside, or indeed to there then being a retrial. Factors such as those that you have identified and which we have sought to deal with are factors that weigh into that, but that will require evidence.
Yes, if you forgive me saying, well, quite for that. If you forgive me saying so, paragraph 16 of your arguments is slightly circular. You say it is a breach of a constitutional guarantee of a fair trial. However, not every constitutional breach would give rise to setting aside a conviction. Oh, sorry. Not quite know how this works. Oh, yes, the question was, if there has been a relevant disparity, is the court bound to set the conviction aside? And you say it is a breach of a constitutional guarantee of a fair trial. However, not every constitutional breach would give rise to setting aside a conviction. So the answer must be no. The answer to the question, is the court bound to set the conviction aside?
Mm-hmm.
Section 21 of the Act is always the test. The question is whether there was a miscarriage of justice, as we submit there was, given the breach of the appellant's constitutional right. So it looks rather as if, in relation to the constitutional right that we're now talking about, which is to have a jury which doesn't have the appearance of bias, which there is if there's more than 3 stood by, subject to the sort of circumstance where in fact the defense agrees, the breach of the constitutional right does lead to the position where the court must set the conviction aside.
I suppose, unless you were to add, Mr. Lynch, in the circumstances of this case, after breach of the appellant's constitutional right.
Yes.
Yes.
Thank you for that.
Right. Part of the reason for my questioning is this. When you look at some of the authorities, they say the disparity between the entitlement of the Crown and the entitlement of the accused is very great. And it can't be right that if the Crown stands by 10 or 26 and the accused can only stand by 3, that can't be right and gives every appearance of bias.
Yes.
Now, it's very easy to take those numbers. One can see without too much difficulties that if the Crown stands by 10 and the accused can only stand by 3, there is a gross disparity. But if the Crown stands by 4 and the accused can stand by 3, it is not so. You say, since the legislature has taken 3 to be the maximum that you can stand by without giving any reason,
yes,
as far as the defense is concerned, that must be treated as the limit. You've got to have a limit somewhere, beyond which standing any greater number by gives rise to the appearance of bias.
I don't see how it can be anything else. I mean, I follow that obviously, if the prosecution of it, having, as I think in one of the cases that Trott relied on, I can't remember the name of it off the top of my head, but there were, I think, 20 something challenges or standbys by the Crown. Tyson, yes, thank you. There were 20 odd standbys by the Crown, as opposed to the 3 that the defence had. Now, it is on its face immediately obvious, but the fact that happened in that case doesn't mean that there can't be, that a line shouldn't be drawn. I mean, it's been decided by Parliament that the line should be 3. And that line is drawn as 3, partly because that is all that the defence have had. And they need not have done that. They could have said, actually, we think that if If it had been 5 or 10, each side can have that many. There has to be, on the one hand, a practical number of challenges that can reasonably be made by either side, and in order to make sure there are always enough jurors anyway. And on the other hand, there needs to be a limit to what is regarded as fair and not raising the spectre of bias. And that line is drawn where it is.
Sorry, I'll stop asking these questions in a moment, but I quite follow that. And you say Parliament must be taken to have drawn the line at 3. But the test for bias is whether it would appear to a reasonable observer that there was a real possibility of bias in the tribunal.
Yes.
The reasonable observer does not necessarily hold the same views as the legislature.
Well, rarely do they.
Quite. But if the test is that imaginary character, the reasonable observer, it might be thought that you shouldn't conclude that once you get past 4, any reasonable observer, once you get past 3, any reasonable observer would conclude that there was an appearance of bias.
Well, I don't see, if I may respectfully say so, how it would be appropriate to do that, merely because, essentially because, once you draw a line, if that line is drawn for the purpose of identifying what can be regarded as a fair number of challenges without raising that spectre, then how can it be that simply because it goes over that line by 1, that it is regarded as being in some way still fair because it's only by 1? In our submission, it's the wrong way to look at it. The right way is why, in response to my Lord Bell, I said in a slightly different way, I suppose, that it's not part of the prosecution's job to utilize all 3 or 5 or 10 or whatever it might be in order to stack a jury in a particular way. They should be using any challenges they have sparingly. And for on the face of it, at least, a reasonable basis for doing so. Which is why I've always said that it is the overall picture that's created. It may be in a particular jury, for example, there are only 4 young black men on the panel. And that is the intention of the prosecutor, to get rid of all young black men, let's say, because the defendant is black. And if that was their intention, then they would only use 4 because there were only 4. And we can't know that. All we can know is that Parliament has decided, here is the line. You step over that line, and there is now prima facie a breach of what you've characterized as the relevant disparity.
Yes.
An exception. All experiments exceptions.
So those are the submissions that we make. Dealt with in paragraph 16 and 17, and in due course of argument in my submissions, the answers to the questions as to setting aside the conviction and whether there should be a retrial.
In 16 and 17?
In my, I mean, it's very short and pithy, if I may say so. In 17, should there be a retrial? Probably not necessarily in every case, and I've sought to deal with that during the course of argument, illustrating occasionally it might not be so. If one takes the Court of Appeal Act in section 21 as the criteria against which the test we're using is to be measured, then you are required to set aside a conviction where there has been a miscarriage of justice. We submit that if you apply that test and bias is thereby prima facie demonstrated, there has been a miscarriage of justice and it should be set aside.
Subject to the proviso that you don't have to do so if you're not satisfied there's been a substantial miscarriage of justice. You say there has.
It's difficult to envisage a scenario in which if there is an accepted potential bias by virtue of going past the threshold. What you've described again as the relevant disparity. If once we've gone past there, then that bias, it's difficult to imagine a scenario in which it can't be a substantial miscarriage of justice if there is bias.
Yes.
There's no question about it. It's not, as I say, I mean, we all know well of the Pinochet case that went to the House of Lords and had to go back to the House of Lords because of a particular judge happened to have a connection he had not mentioned. And the point about it is that there was no one in their right mind, knowing that judge, would have thought for a moment that it would have influenced the outcome.
No.
The reality was that it's no longer an issue. It's the appearance of it. And that's all we have to deal with. Once you have that appearance, it is a substantial miscarriage of justice.
Yes.
Those are our submissions, unless there's anything else I can assist you with.
No, thank you very much. Yes, I think it's Miss Greening we've got to now. Yes.
Greening, you're muted.
Can you hear me now?
Yes.
Yes.
Yes, good afternoon, President and Court of Appeal. I start off by saying that I agree with my learned friend's submissions thus far, and I would just like to add the following. To address the President's first point about my response to the questions, which was in an email dated the 3rd of March at 5:11 p.m.
Yes.
Yes, and I have stated in my oral submissions at the hearing for leave, I do not argue with the Crown as to the number of standbys, those excused, challenged, or who eventually sat as jurors. And then I also add, and I note that the President didn't include this bit of the email when he quoted it earlier. In any event, it is respectfully submitted that there is an appearance of bias. And just to make my position absolutely clear from the very outset, it's my position that the fact that the Crown stood by, or at least attempted to stand by 33 jurors in my case, creates such an appearance of bias that amounts to a miscarriage of justice, and the conviction ought to be set aside on that basis. So in keeping with my learned friend's submissions thus far, that is my position, my strong position.
But can you just help me on this? Because I'm not quite sure where we are. The prosecution has produced a now slightly revised schedule, and that does indeed show that 33 people were stood by, which is a large number.
Yes.
Three of them actually became jurors.
Yes.
So they move out of the picture. And in relation to 28 of them, the Crown effectively says that they were either the judge accepted that they could be challenged for cause, or they were excused. What is not clear to me is whether you accept not merely the number of standbys, but what the Crown says about what happened second time round, and that it was a challenge for cause or an excuse.
Yes, I do accept that 33 were stood by the Crown initially.
Yes.
I do agree that 28 were then excused second time round with cause. Three,
with cause.
Yes.
With cause, right.
With cause, yes. They were excused. Discussion took place with the court and the judge, and they were excused with cause. Three of them sat on the jury.
Mm-hmm.
And 2 of those 33 attempted standbys were successful.
Yes.
Notwithstanding that breakdown, my position is strong in that the fact that the Crown stood up at the start of the trial process and stood by 33 jurors
Yes, I see.
amounts to an appearance of bias.
Yes, I see.
That amounts to a miscarriage of justice. And hopefully, once I get into my submissions a bit more, I'll have explained further why I make that submission.
I see. Well, that's very helpful. Just to make sure there's no misunderstanding, you accept that 33 were stood by, you accept that 3 of them sat,
Yes.
and you accept that 28, I think you said excused with cause, but were some of them excused under the Jurors Act?
Some of them were excused.
Mr. Coelho, there seems to be a freezing there.
Sorry?
What's happened? Oh.
I think Justice Bell said that there was a freezing, but he's actually the one who is not responsive, so I think we may have lost him. There he is. Justice Bell,
Hello?
can you hear me? Your mic is muted.
Process of unmuting. Everything froze for me.
Okay, I think we're good.
Sorry, I'm screening. I have to go back to where we were before. As I was saying, I want to make sure that there's no misunderstanding. You accept, indeed assert, that 33 were stood by the Crown, that of those, second time round, 3 actually sat on the jury, and that 28 were either were either stood down for cause or excused under the Jurors Act. Is that right?
That's correct.
Right. Okay. But you say
That's correct. That's what happened. Yes.
right. Thank you. But you say the fact that you had how many 33 first time round itself is an appearance of bias.
Yes, I do.
Yeah.
And
Thank you.
And hopefully, when I elaborate on my submissions, it will make clear why I make that submission as forcefully as I do. Next, I'd like to address the issue of the saving provision. I have 3 points really to make about the saving provision.
Yes.
Which are mostly in line with what my learned friends have already submitted, but maybe a slightly different take. The first point is about the construction of it. The second point is about the legality principle, which I think also, which sort of refers back to the separation of powers and abrogation of
Forgive me.
rights.
When I said you agreed that there were others, I said stood down for cause or excused under the Jurors Act. It's challenged for cause is the phrase I should have used.
Challenged for cause.
Yeah.
Or
thank you.
Excused, challenged, or eventually sat. Yes, as jurors.
Yes, thank you. Right.
So moving on to the saving provision, the 3 points I would like to make are firstly about the construction of it, secondly about the legality principle, and thirdly about the case that I included in my bundle of authorities, Ferguson, which talks about a targeted group. So in relation to the construction of it, well, on an examination of the saving principle, and it's been read out more than once today, it is submitted by me that it is directed only at preventing technical appeals. And I call them technical appeals based on the numbers of jurors stood by where no unfairness or substantial injustice results. Because remember, the test, which is very much at this court's discretion, is whether substantial injustice has occurred in each case, depending on the particular facts of that case. So going back to what his president was saying to Mr. Lynch just now in the discussion about that, and looking at the test and trying to see whether there has to be a particular test or number, threshold or line in the sand, or whether there's some way of the court being able to look at whether the appearance of bias can change depending, or not change, but the appearance of bias might be looked at in one way in one case and differently in another case, regardless of the actual numbers, or regardless of any sort of hard and fast test in terms of numbers. The purpose of the saving provision in my submission is to stop the retrospective floodgates from opening up to appellants where no miscarriage of justice has occurred. If it may be said, and I've said in my written submissions, if the Court of Appeal did not have jurisdiction to entertain these late appeals in the first place, then you may ask why the legislature felt they had to put it into the Criminal Code Number 2 Amendment Act in the first place at all. It's submitted that it's clear from the use of the words, and when you look at section 5.1, the method of the challenge of jurors under section 519 of the Principal Act before the coming into operation of this act is not invalidated by reason only of the amendment to section 519 of the Principal Act. Accordingly, which refers back to only in subsection 1, no conviction shall be quashed solely on the ground that it results from a trial in which the Crown stood by more potential jurors than the defendant. And in my submission, the legislature have deliberately and consciously and purposefully put these words solely, accordingly, and by reason only into the saving provision to close the door to the retrospective appeals in relation to technical appeals, but to keep them open to meritorious appellants where substantial injustice can be shown and when they're in a targeted group. So the saving provision, in that, leaving aside the issue of Ferguson for a moment, it is submitted by me that the saving provision is not inconsistent with the Constitution, because it doesn't allow technical appeals where there's no miscarriage of justice, but it still allows late appellants to come to the Court of Appeal to make their arguments that substantial injustice has occurred in their particular case based on the facts that are presented.
What exactly, can you give me an example of what you describe as a technical appeal, which the saving precludes?
Well, an example might be where technically the Crown has stood by more jurors than the defense was afforded in the pre-amendment, but where no substantial injustice can be shown because, for instance, in this case, the appearance of bias test has not been met.
For what reason? So for what reason would the appearance of bias test not be met?
Well, to use my particular case as an example, in my case, 33 jurors were stood by. Yes. And that is a flagrant abuse. And I won't be as kind as my learned friend who's saying that they're reluctant to use the word abuse by the prosecutor when they stood by 33 out of 36 available to them. So that would be, in my submission, an example where the appearance of bias is clear.
I think the question was in relation to what you term technical appeal.
A technical appeal is just in relation to the numbers. So if there were perhaps an example where, as the president was suggesting earlier, there were 4 standbys exercised by the Crown. So the reasonable observer sitting in the gallery, or as a potential juror themselves sitting there looking, wouldn't think that the prosecutor, the appearance would not be that the prosecutor was running the show and that the defendant wasn't entitled to that same right. Or, for example, where the prosecutor has stood by has exercised their right to stand by under the old section 519, but has tried to or conferred with the defense to see whether they consent to the prosecutor standing up and standing by that potential juror, for example, where there's no appearance of bias, where there's no breach of constitutional right to a fair trial, and where there's no miscarriage of justice. So the saving provision is operating as a gatekeeper for late appellants, preventing those who don't have the facts available to the court to get over the threshold of substantial injustice, but allows those that do to go through, of which we are one, it is submitted.
Right.
So to answer Justice Smelly's question about the construction of Section 5, subsection 2, it's submitted that it's not worded to express finality. Is everything okay?
I think so.
The word solely is intended to block these what I'm calling technical appeals, and to allow appeals that have demonstrated substantial injustice, which includes breaches of the Constitution, unfairness, and bias. And it allows the court to use the discretion that it is entitled to look at each case on its particular facts to determine whether substantial injustice has occurred, and if it has, whether that amounts to a miscarriage of justice. The second point that I would like to make about the saving provision is about the legality principle. It's submitted that the saving provision could not have intended to deprive an appellant the right of appeal that he would have had under the test of the Ruddock test of substantial injustice. To do so would be in breach of the principle of legality, which governs the relationship between Parliament, the executive, and the courts. It's often associated with the presumption that Parliament does not intend to interfere with fundamental common law rights. Unless expressly stated, the legality principle must be upheld when dealing with fundamental rights, and that's why Mr. Pettingill was at pains to point out the importance of the use of the word fundamental in the Chief Justice's ruling, such as the right to a fair trial, which includes the right to appeal. There must be necessary language, it's submitted, including the saving provision, to abrogate these rights, and that necessary language is not there, including a right to appeal pursuant to the common law where substantial injustice occurs.
So wait a minute, the principle of legality which you rely upon is that an act is to be presumed prima facie not to have intended.
Not to interfere with fundamental rights.
Such as a right of appeal.
Unless there's necessary language or it's expressly stated in the statute, the legality principle must be upheld. And in this case, the saving provision has not expressly stated or used that necessary language. And so therefore it's submitted, it follows that this saving provision cannot get in the way of appellants such as ours here today who want to appeal on grounds of the breach of their constitutional rights.
Right.
In my submissions, I've also included an excerpt of Benyon on statutory interpretation, which just confirms the principle of legal policy that by exercise of state power, the rights of a person in relation to law and legal proceedings should not be removed or impaired except under clear authority of law. And it is presumed that a party is not to be deprived of a right of appeal.
Yes.
And the third point that I would like to make in relation to the saving provision is in relation to the case of Ferguson.
Yeah.
And that talks about a targeted group. As to why the saving provision is incompatible with a right to a fair trial, the case of Ferguson of 2018 in the Privy Council is a case on point. This appeal arises out of an ill-fated attempt to introduce a statutory limitation period for criminal prosecutions in Trinidad and Tobago. The relevant statutory provision was in force for only 2 weeks before it was retrospectively repealed by a fresh Act of Parliament. These proceedings have been brought by a number of persons who would have been entitled to the benefit of limitation but for repeal. Their case in summary is that the repeal was unconstitutional because it was a retrospective abrogation of vested rights, a legislative intrusion on the judicial function and directed specifically against the defendants in particular criminal proceedings. They also say that in the light of the prosecutor's involvement in promoting the repeal, the continuance of the prosecution would be an abuse of process. The appeal was dismissed, but the obiter dicta in paragraph 31 is crucial in my submission in distinguishing that appeal from these. It follows that the challenge to the amending act on this ground can succeed only if it is shown that the terms, although framed generally, would in practice apply only to a limited category of people, including the appellants against whom it can be said to have been targeted. In my submission, the appellants at bar, Roberts, Brangman, and Smiths-William, are not in a general class that the amendment affects, but rather they're in a targeted group. That is a group of appellants where substantial injustice has occurred as a result of breach of their constitutional rights, including the appearance of bias, as a result of the unfair jury selection process at their trial. On that basis, Ferguson is good authority in support of ground one, that is to declare that the saving provision is incompatible with the targeted group's fundamental rights under the Constitution, and this ground ought to be allowed. To deny one category of convicted persons the opportunity to participate in the trial process, which includes a right to appeal, which is afforded to all other convicted persons, is unfair and a breach of their right to a fair trial. It's submitted, therefore, that the saving provision prohibiting one class of convicted persons in a limited and distinct class, or to use the term in Ferguson, they fall into a targeted group, must be declared incompatible with the Constitution and ultimately repealed.
Yes. Just help me a moment. In Ferguson, the persons who were affected by the change of the law were all those who became entitled to a limitation defense when the 10-year limit was in force.
Yes.
And that wasn't treated as a targeted group.
No. Because it was anyone who that change in the law applied to, whereas I'm saying that there's a filter process in this situation as per Ruddock, which allows the appellants to appeal only if they get leave once they've established that or demonstrated that substantial injustice has occurred as a result of what happened at their trial, which is distinguished from the people that would be affected by the change in the law in Ferguson.
Yes.
The common law test of substantial injustice should not be denied to people because a saving provision has been put into an amendment act. That is to deny someone their constitutional rights.
But well, that I follow. You say that the saving provision shouldn't be interpreted as having that effect anyway, and others say that if it did have that effect, it was unconstitutional itself. But it could be said that the saving provision, if it had the effect that the Crown says it has, applied to everybody who in the previous years, going back to really the beginning of time, had been tried by a jury where there'd been more than 3 standbys.
Well, I suppose in my submission, that is where my interpretation of the saving provision is different from the other submissions that have been made. My interpretation is not quite as wide. I'm saying that it is incompatible and should be repealed on the basis that it targets a group, and on that basis it's unfair. But then there's a further filter process that appellants need to go through before they can be considered eligible to appeal. They have to demonstrate, as we did in November, that substantial injustice has occurred, and so to get them through the door.
Or might occur.
Might occur. Yes.
Is it then to be understood, your submission, that you rely on Ferguson if your primary view on the proper construction of the saving provision is not accepted? Because it seemed to me, if that primary view is accepted, why would it be that there's any group that will be targeted? Because if it only is intended to preclude what you describe as technical appeals,
yes,
i.e. appeals which are only going to the sheer numbers of the exercise rather than whether there was a real appearance of bias.
Mm-hmm.
Your substantive basis for appeal is that in your case, in your client's case, there was an appearance of bias.
Yes.
So why would it be offensive if your primary construction is correct? Why would your client fall within a targeted group at all?
I think my submission, at least in my written submissions, is the other way round from the suggestion being made right now. The primary position is that based on Ferguson, the saving provision is incompatible with the Constitution because it targets a group, as per Ferguson. And in the alternative, if that's not accepted, then the argument I'm making about the construction of the saving provision applies, in that it only attaches to, it only prevents technical appeals and allows the ones that can show appearance of bias, etc., through.
I see. Thank you.
In relation to the substantial injustice that I say has occurred, I have to demonstrate, ordinarily, looking at the test of substantial injustice and the cases of Ruddock and Johnson, I would have to demonstrate that on the facts and law of the case itself, another jury would have come to a different result. In this case, however, because—
Is that right? Is that right?
The test of Ruddock and Johnson, I would have to demonstrate that on the facts and law of the case itself, another jury would have come to a different result. However, in this case,
is that right? I mean, what you have to show in order to get leave is that there was or might be substantial injustice, and then if you've got leave, the Court of Appeal in effect determines whether the conviction was safe.
Yes.
But that's not the same thing as having to show that another jury would unhesitatingly acquit.
Yes, President, you're quite right. I think I worded it that way to try and labor the point about, in this case, because the appearance of bias is so insidious and deals with the right to a fair trial in an overall sense, because it is the selection process of the jury itself at my client's trial which resulted in the unfairness. I worded it in that way, but I think the test is, well, yes, the test is of substantial injustice, and whether that substantial injustice amounts to a miscarriage of justice according to the Court of Appeal.
What you say in paragraph 12 of your submissions, ordinarily as per Johnson, I would have to demonstrate it on the facts and law of the case itself. Another jury would have come to a different result.
Yes,
Can't be right.
I think the test is, if substantial injustice can be shown, the Court of Appeal then needs to go on and look to see whether that amounts to a miscarriage of justice.
Yes, precisely.
Be set aside.
Yeah. Okay.
However, this unfairness at bar is about the fairness of the process itself and the right to a fair trial. It is the jury selection process itself at my client's trial which resulted in the unfairness. It's precisely because of this unfairness in the way the jury was selected or attempted to be selected that makes the trial process unfair. And this is where I come to my, I urge or invite the court to look at the situation like this. We're in a courtroom. It's the very first day of the trial. There's various characters, the judge, the clerk, the prosecutor, the defense lawyer, the appellants are behind the dock, or the appellants behind, the defendant is behind the dock. There are various people in the public gallery, including members of the public, potential jurors. And the very first thing that these people, including reasonable observers, are witness is that the prosecution is standing up and down like a jack in a box, saying, stand by, at their own discretion. And in my case, that happened 33 times. And we know, and we've accepted and agreed that 3 of them were impaneled on the second time round, 28 were excused or challenged when they proffered reasons why they should not serve. And actually the prosecution in reality only succeeded in removing 2 of those potential jurors through section 5191. Nevertheless, the picture is one of the prosecution gaming and manipulating the composition of the jury, which is redolent with real or at least apparent unfairness. It's been suggested that because of what happened after those 33 potential jurors were stood by, somehow there's a cure to the unfairness that took place. But it's submitted that the Crown cannot rely on the events that followed their abuse of section 519, from which everything else has flowed. The damage has already been done by then. So we've got this situation where we've got all the people that I have laid out in the courtroom on the very first morning, and the potential jurors and everyone else there have watched this situation with the prosecutor standing up and down saying, stand by, stand by, stand by. Now, the jurors are the ultimate decision makers. The fate of the accused who's sitting there in the dock is in the jurors' hands. And from the outset, these potential and actual jurors observe the prosecutor exercising a right that is not afforded to the defense. It is submitted that this extraordinarily high number of standbys is an abuse of section 519. And more importantly, or most importantly, to my submission, this leaves the jury with the impression as they watch over this process that the prosecutor is somehow more important, more powerful, has more influence over who sits on the jury and over the whole process.
But just, Ms. Greening, just to interrupt there, that might have been an initial superficial reading of the process. But by the time that the standby exercise has been gone through again, and it's the judge who's deciding whether the jurors have done sufficient to challenge for cause, it surely is going to be very clear both to the potential jurors and to the defendant that the judge is running the show.
In my submission, not. The damage has already been done because the prosecutor, who has exercised this unlimited right of standby and in my submission abused it, has created an environment that is impossible to undo.
Well, it wasn't done. That's the whole point, because the standbys were not the last word on the subject. The last word on the subject went to the judge, and when they went through the exercise again.
We know that because we...
So does the defendant, and so did the jury.
Well, in my submission, we know that because multiple lawyers, Court of Appeal judges, we've all sat down and done complicated tables and exercises and read transcripts and gone through everything over multiple days to put these submissions together. But the reasonable observer sitting there on their very first day of the trial, and most importantly, the jurors who are going to try the case, their very first impression of what is going on there is that the prosecutor somehow has more control, more influence, and more say over what is going on than anyone else. And once that environment is created, not only does it create an appearance of bias, but it itself is bias. It lends itself to bias, real bias. So
who is biased?
There's a bias in favor of the prosecution.
Yes, but unfortunately what we're concerned with whether there was an appearance of bias of the jury.
The issue that we're looking at here is whether there's an appearance of bias, whether the process itself, the trial process itself, is rendered unfair because of the appearance of bias in the prosecutor having an unfair advantage over the defendant. The defendant in that situation has no voice, is not entitled to the same rights that the prosecutor is utilizing and abusing. And the first impression, taken from the members of the public sitting in the gallery, and more importantly to the jurors sitting there, is that this guy or girl has got more weight, clout, and power over this process certainly than the defendant, or even maybe even more so than the judge at that time. There's an uneven playing field created by that first part of the process, where the prosecutor has an unlimited standby, notwithstanding the fact that later on in the trial that is undone by the potential jurors coming up for a second time and explaining why they can't sit and being excused either by the Jurors Act or by the court. Mr. Lynch referred to briefly the UK guidelines, and I think it is important to remember that the UK guidelines issued by the Attorney General has made it customary for those instructed to prosecute on behalf of the Crown to assert the right only sparingly and in exceptional circumstances. It's accepted that the prosecution should not use the right in order to influence the overall composition of the jury with a view to tactical advantage. It would be clear to any reasonable observer looking at what the prosecutor was attempting to do by standing by so many of the potential jurors called up, was gain a tactical advantage over the defendant, who at that point has absolutely no voice, is entitled to no rights. I agree with the president when the suggestion was made earlier that would it be, or the question was put out there earlier, would it be different if the prosecutor was to stand up and say to the defense lawyer, I want to stand this person by, do you agree? And if the defense lawyer said yes, we'd be entering a different situation. We'd be entering a situation where the playing field was being leveled out a bit more, where the defendant was given a voice, provided the prosecution, didn't stand them by if the defense lawyer didn't agree. The whole process of standing by, or attempting even to stand by 33 jurors, leaves the fair-minded and informed observer to conclude that there is a real possibility that the trial process is biased and in the prosecution's favor. It looks like the prosecutor has an unfair advantage over the defendant, because it does. It creates a perversive air of unfairness in the jury selection process. Fairness must be the guiding principle of justice and the hallmark of all criminal trials. And this process, as viewed by the reasonable observer, is not fair. Abusing Section 519 by attempting to stand by as many as 33 jurors which provided the Crown with the ability to select a jury that appeared to be favorable to it, even if it did not result in all of those being stood by in reality, taints the entire trial process in the same way that the Miller and Dixon case shows from the start, with the appearance of obvious and overwhelming unfairness. And the community will be left in doubt about the validity of such an abusive process. It's submitted that this abuse is contrary to the Nolan Principles of Public Life, which is a list of 7 ethical standards for public officers to adhere to, at least in the UK. Those principles include integrity, objectivity, and honesty. And I know that Scotland has recently increased it to 9. Similarity can be drawn from the case of Miller and Dixon, where it was held that a biased judge, or a sheriff in that case, because they were in Scotland, contaminated, and I like the word contaminated, the fairness of the entire trial to show to such an extent that it did not matter that the evidence against the accused was strong. And that's in contrast to what I was saying earlier about the Johnson case and the test about looking at the facts and circumstances of the case. It shows a de novo unfairness to the accused, something that the accused cannot escape from. Before the Privy Council, the Solicitor General in the Miller and Dixon case tried to argue that the right to a fair trial had to be viewed in the context of all of the facts and circumstances of the particular case to weigh the alleged infringements against the general interest of the public. The court did not agree with that position. The ultimate issue was one of fairness, viewing the proceedings as a whole. Lord Bingham and Lord Hope rejected the submissions of the Solicitor General and referred to the Court of Appeal decision of Lochaber, 2000 case. In determination of their rights and liabilities, civil and criminal, everyone is entitled to a fair hearing by an impartial tribunal that has not just witnessed the prosecutor running the show at the very start of the proceedings to which they are going to be the trier of facts. That right, guaranteed by the European Convention for the Protection of Human Rights and Fundamental Freedoms, or the Bermuda Constitution here, is properly described as fundamental. The reason is fear or favor, affection or ill will that is without partiality or prejudice. Justice is portrayed as blind, not because she ignores the facts of circumstances of individual cases, but because she shuts her eyes to all considerations extraneous to the particular case. Any judge, for convenience, we shall say in this judgment, use the term judge to embrace every judicial decision maker, whether judge, lay justice, or juror, who allows any judicial decision to be influenced by partiality or prejudice, deprives the litigant, or the appellant in this case, of the important right to which we have referred, and violates one of the most fundamental principles underlying the administration of justice. Where in any particular case the existence of such partiality or prejudice is actually shown, the litigant has irresistible grounds for objecting to the trial of the case by that judge or jury, if the objection is made before the hearing, or for applying to set aside any judgment given. Such objections and applications based on what in the case law is called actual bias are very rare, partly, as we trust, because the existence of actual bias is very rare, but partly for other reasons also. The proof of actual bias is very difficult because the law does not countenance the questioning of a judge about extraneous influences affecting his mind. And the policy of the common law is to protect litigants who can discharge the lesser burden of showing a real danger of bias without requiring them to show that such bias actually exists. Lord Hope explains his rejection of the argument by the Solicitor General in the following terms at paragraph 63. In my opinion, this argument overlooks the fundamental importance of the Convention rights to an independent and impartial tribunal. These two concepts are closely linked, and the appearance of independence and impartiality is just as important as the question whether these qualities exist in fact. Justice must not only be done, but it must be seen to be done. The function of the Convention right is not only to secure that the tribunal is free from any actual personal bias or prejudice, it requires this matter to be viewed objectively. The aim is to exclude any legitimate doubt as to the tribunal's independence and impartiality. As Lord Clark said in Rimmer versus HMA, the question of impartiality, actual or perceived, has to be judged from the very moment when the judge or tribunal becomes first seized of the case. And that's important in my submission because I'm looking at what the very first impressions that the potential jurors and members of the public and reasonable observers glean from the prosecution's unlimited right to stand by and abuse of that old provision. It's a question which, at least in a case of perceived impartiality, stands apart from any questions that may be raised about the character, quality, or effect of any decisions which he takes or acts which he performs in the proceedings. Lord Hope expresses his conclusion at 65. The principle of the common law in which these cases depend is the need to preserve public confidence in the administration of justice. See Dimes versus Proprietors of Grand Junction Canal, 1852. R versus Goff, 1993, per Lord Goff at Chively. It is no answer for a judge to say that he is in fact impartial, that he abided by his judicial oath and there was a fair trial. The administration of justice must be preserved from any suspicion that a judge or jury lacks independence or that he is not impartial. If there are grounds that would be sufficient to create in the mind of a reasonable man sitting in the public gallery watching this situation unfold, a doubt about the judges or jury's impartiality, or trial process, the impartiality of the trial process itself, the inevitable result is that the judge is dissatisfied from taking any further part in the case. No further investigation is necessary, and any decisions he may have made cannot stand. The Solicitor General's submission that the matter, if raised after the event, should be considered in the light of all the facts bearing on the question whether there is a fair trial is contradicted by this line of authority. In my submission, it is hard to imagine a situation more biased than a prosecutor standing down or attempting to stand down 33 jurors at the start of a trial where potential jurors are watching and gathering their first impressions of the trial process, how it works, who's in control, who they should be listening to, coupled with the fact that, and I'm not sure where we are in terms of the fresh evidence, that the prosecutor was working with the police, who are also witnesses for the prosecution, to manipulate the jury selection process as occurred in this case. On that point, where we talk about the prosecution working with the police and the other supporting agencies to decide who they're going to stand by or try to kick off the jury, there is already, as we know, a comprehensive system for vetting who should be put onto a jury pool under the Juries Act. The creation of the revising tribunal, who are tasked with the removal of potential jurors before the list is made up, removing those with previous convictions and citizens who are not fit and proper to sit as jurors under sections 3 and section 8 of the Juries Act. It's an abuse in my submission for the police and prosecution to be taking it upon themselves to carry out a second filtering process to their advantage, and certainly of any reasonable observer sitting in the public gallery, God forbid any of those be the potential jurors themselves who end up sitting on the jury panel, see the prosecution and police or supporting agencies conversing verbally or non-verbally with one another while the jury ballot or the juries are being selected out of the bowl by the clerk. There's no doubt that those reasonable observers will gain an impression that is terribly unfair to the defendant. It's an abuse for the police and prosecution to be taking it upon themselves to carry out a second filtering process to their advantage, and any attempt to do so in the courtroom creates an appearance of bias and is bias in itself. The independence and impartiality.
Sorry, an appearance of bias of whom?
An appearance of bias of the trial process itself. The
Right.
entire process itself is tainted and contaminated in the same way that the impartial, the partial sheriff in the Miller and Dixon case contaminates or taints the entire process at the appellant's disadvantage. The independence and impartiality of the tribunal by which an accused person is tried is a central feature of our criminal law that has long been recognized. The importance of this right in Bermuda is illustrated in the entrenchment of Section 6. Standing by or attempting to stand by 33 jurors impairs the appearance of impartiality and is therefore unconstitutional. It renders the conviction unsafe for any trial in which that process has taken place. For the avoidance of doubt, this is specifically because of disparity between how the prosecution has operated and been allowed to operate in this case as compared with the accused. This asymmetry produces an appearance of partiality sufficient to amount to an infringement of Section 6. It is established that there is no difference between the common law test of bias.
Ms. Greening, sorry, I have to interrupt you. It appears that the president has dropped off. All right, Justice Smelly and Justice Bell, if we could just take a 5-minute adjournment so that we can sort out Sir Christopher and come back. So could you go over to the judge's room?
Yes, that seems to make sense. Justice Bell?
I don't see a prompter for the breakout room for the moment.
Do you have on the screen? You take the cursor to the bottom, one of the options given should be a breakout room.
Yeah, I've got it now. It's only just a thing.
4 white boxes, yeah.
Yep.
Kyrie, can you hear me? If you can, just put your thumb up. Good. Everything all right? Okay. Thumb up.
Let me see, goodbye, guy. Good job, man.
Oh. Sorry. Oh, it's such a big task, isn't it? Muting it and unmuting it. How can you manage? Here we go. All right. Now,
Just to advise counsel and the appellants, we are still recording, so if you need a private room, I'm happy to facilitate that.
Thank you very much,
Mr.
As far as I'm concerned, I'm content just to see that everything is all right. I was just going to ask my client, Mr. Kyrie Smith-Williams, if he's okay. Everything all right? If I get a thumbs up, I'm content with that. I don't need a breakout room. We can have a call later on if necessary. Thank you.
Good, Quince?
Yeah, cool.
You follow?
Yes. Well,
Like
how
that?
about when this ends? 4 or 5 o'clock?
Not sure because
Earlier.
they're in England, so it'll be earlier than that.
Okay, I do it there's on Bermuda time.
No, the president's in England.
Right. I understand that. I do it being in Bermuda, we was rocking with Bermuda time. I don't know.
No, he calls it. Well, it should wrap up soon.
Okay.
All right. Call me later if you want to chat about anything.
All right, thanks.
Okay.
back on.
Okay, do we have Ms. Greening with us? All right, I think everyone's in place.
Yes, President, Court of Appeal.
Sorry about that. There was a breakdown of communication, literally.
I had finished off before the break talking about the provisions in the Juries Act for the revising tribunal and the role that they play in filtering out people from the jury pool before they even get to the first day of trial. And the reason that I felt it necessary to raise this and point this out and go into some detail is to show that it is highly inappropriate for the prosecution then to go on and conduct what I was calling a second filtering process with the with the police and other supporting agencies, at all, but particularly in the presence of members of the public, the defendant, and potential jurors sitting, waiting to see whether they were going to sit as jurors in that case. And the appearance of bias of the trial process itself that would create. I'm now going on to read out the law that shows there is no difference, or it's established law that there is no difference between the common law test of bias and the appearance of bias that is central to these submissions and arguments and appeal, and the requirements under the Constitution. The case that lays it out and is cited in the local case, the constitutional case of Jamaica Trot, is Lowell versus Northern Spirit Limited 2003. It's a House of Lords case cited in the Trot's constitutional case. The issue before the appellate committee.
Where will we find it?
If you look in the Jamaica Trot's constitutional case at paragraph 30.
And that's where you want us to go, Ms. Greening, to the CJ's judgment?
Yes, if you want to follow along where I'm reading, you'll see at paragraph 30, I'll read from 31.
The issue before the appellate committee?
Yes, my lord. The issue before the appellate committee in Lowell was whether, in circumstances in which a Queen's Counsel appearing on an appeal before an Employment Appeal Tribunal, EAT, had sat as a part-time judge in the EAT with one or both of the lay members, called the wing members, hearing that appeal. The hearing before the EAT was compatible with Article 6 of the ECHR and the common law test of bias. It was not suggested that there was actual bias. The question was whether, in the view of the fair-minded and informed observer, there was a real possibility of subconscious bias on the part of the lay member or lay members. In agreement with the view expressed by Justice Stevenson in Bain, which is a Canadian case on jury selection.
We've had this passage read to us, haven't we?
Yes.
Yes, okay, so, and that just lays out the test in Porter and McGill and hammers home the point that there is no difference between the constitutional right to a fair trial and the appearance of bias. Then there's the Privy Council case of Tyson from the BVI that challenged the provision that permitted the Crown unlimited right to stand down jurors, which was found to offend the equality of arms enshrined in the Constitution identical in its terms to Section 6 of the Bermuda Constitution. It was held that the vastly superior position of the Crown, when compared to the accused right of 3 preemptive challenges, raised an issue of bias. And in my submission, although in our case, in my particular case, the end result is that only 2 of the attempted 33 standbys were removed, the appearance of bias created in attempting to get rid of 33 and the entitlement by the Crown to do that is enough to amount to a miscarriage of justice or unfairness, and therefore a miscarriage of justice. It's now accepted that there is no difference between the test of apparent bias and the requirements of an independent and impartial tribunal under Article 6 of the European Convention, which is identical in its terms to the Section 6 here. The characteristics of the fair-minded and informed observer are now well settled. They must adopt a balanced approach and will be taken to be a reasonable member of the public.
Could you just tell me where you're reading from? Oh, I see, paragraph 34. Thank you so much. Yeah.
They must adopt a balanced approach and will be taken to be a reasonable member of the public, neither unduly complacent or naive, nor unduly cynical or suspicious. I do believe that a fair-minded observer, knowledgeable in the pertinent aspects of the criminal trial system, and particularly the operations of the jury selection process, would perceive a real possibility of bias in favor of the Crown in the potential application of Section 27B, equivalent there to 519. I am also of the opinion that Section 27B infringes the substantive fundamental right to a fair trial by an impartial court. I do believe that the perception of bias in the jury selection process would contaminate and lead to a real perception of bias in relation to the trial itself. The two would be inextricably linked. I agree with Justice Corey when he stated in Bain that where the jury by its manner of selection would appear to favor the Crown over the accused, the effect was that the whole trial process would be tainted with the appearance of bias and overwhelming unfairness. In the Canadian Supreme Court case of Barrow, Chief Justice Dixon commented in similar vein as follows, and I'll just end with this bit. The selection of an impartial jury is crucial to a fair trial. The accused, the Crown, and the public at large all have the right to be sure that the jury is impartial and the trial fair. On this depends public confidence in the administration of justice. Because of the fundamental importance of the selection of the jury, and because the code gives the accused the right to participate in the process, the jury selection should be considered part of the trial for the process. The jury selection part of the trial for the process. The jury selection process should be considered part of the trial for the purposes of Section 577, now 650. The Chief Justice in the Trott case agrees with Gonslaves in the Tyson case that the appearance of bias on the part of the court is in itself sufficient to demonstrate a breach of an accused person's fundamental right to a fair hearing by an independent and impartial court, and constitutes a breach of Section 6 of the Constitution. In my submission, standing by or attempting to stand by 33 jurors in the face of the court, in the presence of the jury that end up trying the appellant, and in the face of the accused, amounts to a miscarriage of justice for the same reasons. The appearance of bias and the unfairness such as this, as demonstrated, involves much more than a new law replacing an old law. It undermines and contaminates the whole trial from the outset and amounts to substantial injustice. It renders the conviction unsafe. On this basis, I invite the court to allow this appeal. It's further submitted, going back to the saving provision, that the saving provision of the Amendment Act does not apply, is discriminatory in nature, and in breach of the appellant's right to a fair trial pursuant to the Constitution, and ultimately it ought to be struck down. In the alternative, and I think this answers Justice Smelly's question earlier, it is respectfully submitted that the substantial injustice demonstrated on the facts of this case, namely the appearance of bias and unconstitutionality or breach of the Constitution mean that the narrow construction of the saving provision allows the appellant the right to appeal as per Ruddock. Those are my submissions. At this stage, I reserve the right to elaborate, particularly on the fresh evidence point, if I'm invited to do so later down the line.
Yes. Thank you very much. Now, where have we got to? I think we've got to Mr. Mahoney.
Yes.
Have we still got him?
Yes, I believe so.
Yes, I'm here, sir.
Oh, good.
I'm just trying to my authorities together. Good afternoon, sirs and colleagues. I just want to start out by addressing a few points that my colleagues raised in their submission. And in answer, I'll deal with Ms. Greening first. Ms. Greening's case has to be seen in context. That was a case in which there were two defendants who were being tried at the same time, Christopher Deere and LeVeck Roberts. There were two deceased persons. And the majority of the standbys, which eventually, I think 28 of them were for cause, were connected with one or other of the deceased or the accused in the main. So when my learned friend is pontificating about 33 challenges, it is not 33 challenges against her client. Those challenges have to be seen in context. And even so, when we, after the numbers, the 28 that were successfully challenged for cause or excuse, and that were who eventually sat on the panel, the two that remain, one have to remember that there were two defendants in the case. So if one was to be fair, there was really one standby challenge in relation to this defendant. One want to be generous, it boils down to two.
Mr. Mahoney, why then stand by in the first place if you have cause to challenge?
The general practice, sir, in these courts is that you you stand by, because many times the whole process of establishing cause is usually takes some time in going into that procedure. And sometimes the judge may wish to have the jurors out, the other prospective jurors out to deal with the question of cause, sometimes depending on who the judge is. So what normally happens is you stand by and see if you can get a panel without having to pause to go into the issue of cause. Most times, that's what happened.
I see.
But in this particular case, because of it was a two accused case, two deceased case, there was a lot of competing interests at the same time. So we were trying as much as possible to empanel a jury without having to go through the whole issue of cause. And you will notice from the transcript that going through the standby jurors on the second round took some time. On that point, just to respond to my learned friend, Mr. Lynch and Mr. Pettingill, which seems to give the impression that the exercise of the standby was in effect to get rid of the juror once and for all. That is not true. The case of Roberts is a perfect example of what happened when the juror is stood down or stood by, and then you go around the second round, in which case the prosecutor, unless you can establish cause, the person sits on the panel. So once a person is to stand by, they don't leave. They have to sit in court until the panel is properly constituted. Then the judge will indicate whether or not they could leave. That is if they are not excused for cause or before, for some other reason. In relation to standing by as well, sometimes a juror, it is not recorded, but I think there was one of these cases. I'm not sure if it was Kyrie Smith-Williams or the LeVeck Roberts case, where if you listen, you actually hear communication between counsel, which is not fully recorded on the system, and then counsel will say standby. Mr. Pettingill had indicated that sometime we may get an indication from the defense counsel by way of a note, sometime by look. I know that with Mr. Lynch, I've appeared in matters with him where a prospective juror is coming in. Let's say, for example, a lady on her walking stick and she's shaking and coming in. We may look at each other and you may get a facial indication from counsel that, you know, no problem, stand by this person, and you stand by the person. So not everything is recorded on the system.
But Mr. Mahoney, that doesn't help us in, we can't pick that up from the transcript, can we?
That is so. That's why I'm saying not everything is recorded. And Mr. Pettingill, I believe, had indicated this before. So that's, I just wanted to put that out there. In respect of Mr. Brangman as well, I'm not sure if Mr. Pettingill was taking issue with his client, because based on what we saw during the transcript, we stood by 3 persons. In effect, the others, we stood by more, but they were eventually excused for cause by the judge. Kyrie Smith-Williams, we said,
I don't know. I thought that in Brangman, there was an agreement that the number of standbys was greater than 3.
No, sir. Well, there were 6. I think there were 6 or 7, but they were eventually excused for cause because persons were connected with one party or the other. So if you were to deduct those for cause that the judge eventually excused, you end up with only 3 persons where the Crown had standby with no reason given.
Well, we may have to go into the details of that.
Yes, sir.
Just before we move on, in relation to Roberts, can you tell me who are the 2 who it's accepted were stood by and not subsequently excused or eliminated for cause? We go to page 410 of the Record of Appeal. We've got your amended schedule of jurors.
Could I ask my colleague to check on that, sir?
Yes, I don't need the answer now.
Yes, that will require me to go through the whole list.
Well, quite. But I'd like to know who the 2 were. If it helps your learned junior, it seems to me likely that they were standby jurors numbers 15 and 17, but that's only a guess. Right.
Yes, sir. I'll ask my colleague to try that, and we'll get back to the court with that answer.
Yeah.
In respect of there was a Mr. Pettingill and I think Miss Greening actually raised obliquely about the composition of the jury. And we filed a document which assists the court in what was the racial composition of the jury. In respect of Roberts, there were 10 persons of African Caribbean descent and 2 white persons, and all 12 reach a unanimous decision.
Mm-hmm.
In respect of Brangman, I'm trying to, some documents are in different bundles, sir. But I know in respect of Kyrie Smith Williams, it was 6-6, I believe, 6 white, 6 black. And in respect of Brangman, it was predominantly black. I think it was 3/4 black. But I'll ask my colleague to double check that, please.
The composition of the eventual jury is perhaps not so important as knowing who the people are, or the racial composition of those who were excluded.
Excuse me, sir?
Knowing the racial composition of the eventual jury is perhaps not so significant as knowing the composition of those who were excluded.
Well, my lord, I think that would be difficult because the submissions of my learned friend would give the impression that the jury was stacked in such a way that it was white Bermudians predominantly on these cases against these young black Bermudian males. When in fact, the fact is that that's not so.
Well,
started off with that. Excuse me, sir?
I hear what you say.
Yes, sir.
But bear in mind Mr. Lynch's example of 3 or 4 young black males stood by, and the defendant was a young black male. I mean, that obviously has a significant impact on the racial composition of the jury.
Well, it's unfortunate Mr. Lynch did not indicate that in his submissions, because I would have had the opportunity to go and do the research.
Right.
I don't want to be speculating off my head now. That's why I focus on what was in their submissions. And these belated aspersions being thrown around, it doesn't put us in a proper position to assist the court with the actual facts.
Okay.
In respect of the questions that were asked, the first question, whether the principle of finality applies.
Yes.
Our submissions that it does apply, sir. I will start with the authority that Mr. Lynch started off with. A, and Governor of Arbor Hill Prison.
Yes.
And he invited the court to look at, would have been page 16 of 42.
Just a moment.
Yes, sir.
You remind me that was in the supplemental bundle of authorities, Mr. Mahoney.
This would have been in the respondents. supplemental submissions addendum.
Yes.
That what was filed on the 5th of March, Mr. Mahoney?
Yes, it was.
This would have been what was sent from Ms. Lindo, Justice Smelly, just before. lunch.
Okay. Right.
Well, wait, just a moment, just a moment. We were looking, I was finding A against the governor of Arbor Hill Prison. We looked at it in the joint authorities bundle, where it starts at 404. And what we were looking at was the decision.
Justice at 425.
425.
Yes, that's right. Thank you.
My lords, I must indicate that the joint authorities.
Yes.
I'm having some technical issues with my computers today, so I'm actually relying on the hard copy until I can resolve my computer today.
Right. Well, can you tell us where we should look in the hard copy?
Well, my learned friend invited the court to look at page 16 of 42. And I would invite the court to look at page 22 of 42.
I'm sorry, I think we've got different pagination.
Yes, I don't have the same.
Oh.
Can we have you got the paragraph numbers?
The one I have doesn't have any paragraph.
Whose judgment is it?
Excuse me, sir?
Whose judgment is it?
This is a judgment of the Chief Justice, Moral Chief Justice.
It begins at page 425 of the bundle.
Yes.
And you haven't got any paragraph numbers?
No, the one that I have doesn't have paragraph numbers.
Well, what page number did you have?
From my copy is page 22 of 42. So the counsel had stopped.
Well, just a moment.
Yes, sir.
In the joint authorities bundle, the version of the case that I've got, which has in the pagination in the top right-hand corner, the decision of the Supreme Court starts at page 22. And I'm wondering whether that may be the same pagination as you have.
Criminal indulgence, sir. My colleague is bringing it up.
If it's of assistance, I think it may be paragraph 170 that my learned friend is trying to take your lordship to.
That's headed conclusion?
It's headed conclusion. It's a second conclusion in the Chief Justice's judgment. I think that's where he's trying to take you.
Yes, thank you, counsel.
Sorry, which paragraph are we looking at?
170.
That's the page 458 of our bundle, the hard copy bundle.
That's not what I read.
Well, that's part of the judgment of Mr. Justice Denham.
I'm sorry, sir. It's the paragraph that starts with the principle of judicial review of the constitutionality.
Yes. That does appear to be Justice Denham's.
I'm sorry, Justice Smelly, can you tell me which paragraph number it is? Oh, paragraph 170, yes.
Yes. But that does appear to be the conclusion to Justice Denham's judgment rather than the Chief Justice Murray's judgment.
Well, that's a paragraph I'm relying on, sir. Conclusion, the principle of judicial review of the constitutionality of a law by the superior courts was a novel aspect of the Constitution of Ireland, 1937. Ireland led the common law world by expressly incorporating this power into the Constitution. Such power carries duties. Over the years, the courts have developed constitutional principles and presumptions relevant to the exercise of such a constitutional duty. No principle of retrospective application of a declaration of unconstitutionality has been developed. To the contrary, the application of declarations of unconstitutionality has been limited to the parties or identified litigants and prospectively. There is no express principle of retrospective application of unconstitutionality in the Constitution. I'm satisfied that no such principle may be implied into the Constitution. Such a principle would bring disorder into society disproportionate to the benefit to be achieved. Such a principle would render the express power given to the superior courts a tool of chaos. The issue of the general retrospective application of the Declaration of Unconstitutionality was not dealt with in CC and Ireland, nor was there any query raised subsequently by any party about the application of the judgment. Instead, this issue has been raised in subsequent unrelated litigation, this case. Prior to the declaration of its unconstitutionality last May, Section 171 of the criminal law, and it goes into the the facts of this case, was treated as the law of the land. While the court order is to the effect that the section was not continued in force by Article 50, subsection 1 of the Constitution, and so it is deemed invalid since 1937, this does not reflect the reality of the situation since 1937. The reality is that it was assumed that the law was constitutional. It has been acted upon for 70 years. Over the decades, people have been prosecuted, convicted, and acquitted on legislation. A section of law has been relied upon. People have altered their positions detrimentally because of the section. The state, via many instruments, has acted upon the section. It occupied the position of a law which must be observed until it was struck down as unconstitutional. While it has been declared that the section is inconsistent with the Constitution and thus not carried over in 1937, that decision does not address its application outside the case in which it arose. There is no principle of the retrospective application of a declaration of unconstitutionality outside the particular parties of a case or litigants specifically named by the court. This has long been the practice in this jurisdiction, which practice upon sound constitutional principle. Organized society and the common good are protected by the Constitution. This includes the orderly administration of justice. Justice is not served, nor is the reality of the situation in our community served by applying retrospectively an invalidity in circumstances where a law has been relied upon by all for many years. Such a principle of retrospective application would be the antithesis of law and order. Contemplate a situation in 1976 if a retrospective application of the Barker had resulted in all the prisoners tried by such juries released. Contemplate a situation in 1982 if retrospective application of Murphy applied and the revenue commissioners were required to return all the invalid taxation collected from all married couples over the years. To borrow from Chief Justice O'Higgins, organized society could not accept such a conclusion. The Constitution does not require such a conclusion, and nor have the courts. A court is required to differentiate between the declaration of unconstitutionality and the retrospective application of such a decision. While in cold logic, all such declarations are null and void since 1937 or the date of a post-1937 purported legislation, application of such a ruling is a further issue for consideration. Consequently, it is a matter of construing the Constitution to determine how such a decision should be applied in a manner consistent with the principles of the Constitution. The fact that there is no principle of retrospective application of a declaration of unconstitutionality outside the case or cases in which the issue was decided has, quite remarkably, not been the subject to date of express judicial decision in Ireland, although it has underpinned the practice and application of the law for many years. When a law has been treated as valid law for decades, it's impossible, unjust, and contrary to the common good to reverse the many situations which have arisen and been affected in all their myriad forms over the decades. In fact, even if a law has been presumed valid for only a few short years, it will have affected people and institutions in ways not reversible. The community accepted the law the way it was assumed or presumed it to be and acted accordingly. The clock cannot be put back. The egg cannot be unscrambled. Indeed, this fact is one of the reasons why consideration may be given by the President of Ireland to sending a bill to the Supreme Court under Article 26 of the Constitution. Such an action by the President, if the bill is found to be unconstitutional, prevents irreversible consequences. Once a law is applied in a community, it has ripple effects which are irreversible. This particular case was actually relied on in other that I had relied on when we were dealing with the leave application. But just to go back a bit, it's a lot of law in this authority, and I'm not sure if the court may want me to go through all of it. You'll recall that where counsel had asked the court to look at, that's Mr. Lynch in this authority. It comes just after the court examined authorities from different jurisdictions, including the Canada and the USA and the European Convention on Human Rights. And in a nutshell, they said that there is no law in regards to retroactive application of a change in the law. From that authority, I wish to go to the case of in Ruddock. Although Ruddock's case was dealing with the common law principle where there are developments in the law, there are certain aspects of it that are applicable here. And in the case of Ruddock and Jogi, or Jogi, 2016 UK Privy Council.
And where is that in?
Ruddock is in our supplemental bundle of authorities, pages 34 to 71.
Yeah.
Paragraph 100.
Just a moment. Do you know what page it is in the supplemental bundle?
Page 67.
Thank you. Yes.
Paragraph 100. It's that the effect of putting the law right is not to render invalid all convictions which were arrived at over many years by faithfully applying the law as laid down in this particular instance, Chang Win Su and in Powell and English. The error identified of equating foresight with intent to assist rather than treating the first as evidence of the second is important as a matter of legal principle. But it does not follow that it will have been important on the facts to the outcome of the trial or to the safety of the conviction. Moreover, where a conviction has been arrived at by faithfully applying the law as it stood at the time, it can be set aside only by seeking exceptional leave to appeal to the Court of Appeal out of time. That court has power to grant such leave and may do so if substantial injustice be demonstrated, but it will not do so simply because the law applied has now been declared to have been mistaken. This principle has been consistently applied for many years, nor is refusal to leave limited to cases where the defendant could, if the true position in law had been appreciated, have been charged with a different offense. An example is Ramsden, where a defendant who had been convicted of dangerous driving before Gosnell held that the fault was a necessary ingredient of the offense, was refused leave to appeal out of time after the latter decision had been published. The court observed that alarming consequences would flow from permitting the general reopening of all cases on the ground that the decision of a court of authority had removed a widely held misconception as to the prior state of the law on which a conviction which it was sought to appeal had been based. No doubt, otherwise, everyone convicted of dangerous driving over a period of several years could have advanced the same application. Likewise, in Mitchell, Lord Justice Godfrey Lane restated the principle thus: it should be clearly understood, and this court wants to make it even more abundantly clear, that the fact that there has been an apparent change in the law, or more precisely, that previous misconceptions about the meaning of a statute have been put right, does not afford a proper ground for allowing an extension of time in which to appeal against conviction. For more recent statements of the same rule, see Hawkins and Fletcher, together with the cases referred to in R&R. Scotchell and Fletcher decides the same principles must govern the decision of the Criminal Cases Review Commission if it is asked to reconsider referring conviction to the Court of Appeal, see in particular paragraph 58. And likewise, in the case of Bestel, Raza, and Bashir, this should be the case before Ruddock. This is our respondent's authority in respect of the leave application.
Starts at page 2, Sir Christopher.
What?
Starts at page 2 of the same bundle we were just looking at.
That's Bestel.
Oh, Bestel.
Bestel.
Yes.
Bestel. Specifically at paragraph 11, cases on the principle of finality. In the Queen and Mitchell, the defendant was convicted of possessing cannabis with intent to supply. He was granted leave to appeal against sentence. In the meantime, the Court of Appeal held in the Queen and Goodchild that cannabis within the meaning of Section 37, subsection 1, Misuse of Drugs Act 1971, did not comprise merely the leaves and stalk of the cannabis plant. Possession was unlawful only if it was of those parts of the plant from which resin could be extracted. On appeal against sentence, it was demonstrated fortuitously, since the prosecution's expert happened to be in court, that the defendant had been in possession of parts of the plant from which no resin could have been extracted. The defendant applied for an extension of time within which to appeal against conviction. Lord Justice Lane, later Chief Justice, acknowledged the principle of finality applied by the court in the Queen and Ramsden, in which the court declined to reopen out of time a conviction for dangerous driving following the Court of Appeals decision in the Queen and Gosney, that driving as a dangerous driving was dangerous only if the driver was at fault. However, the court was informed that the defendant was about to complete a concurrent sentence imposed for handling stolen goods. No action was taken. The defendant would be required to serve a further sentence of imprisonment in respect only of an offense which under the change law he had not committed. In the circumstances, the court exercises discretion to permit an extension of time. Several other cases are relied on, and I will just forward to the next page, which is under paragraph 13, Queen and Hawkins. The court was considering the consequences on other previously completed cases of a change in the interpretation of Section 15 of the Theft Act by the House of Lords in the Queen and Preddy. The defendant was seeking an extension of time of some 7 months in order to take advantage of the change in the law. The court refused the extension of time, concluding that on the facts there had been no substantial injury to the applicant because his admitted dishonesty would have permitted other charges under the 1968 Act and the Theft Act. The court accepted the submissions made on behalf of the prosecution described by Lord Bingham, Chief Justice in the Queen and Hawkins. Counsel goes on to submit that a change in the law since the date of conviction or plea of guilty has not usually been regarded in the past as good reason for granting an extension of time in which to appeal in support of the submission. He has drawn our attention to Queen and Lesser, Queen and Ramsden, and in Berkeley and Queen and Mitchell. Lord Bingham, Chief Justice, observed at page 240 that practice may on its face seem harsh. On the other hand, the consequences of any other rule are equally unattractive. It would mean that a defendant who had wrongly and unadvised accepted that he had acted dishonestly and fraudulently and pled guilty, or who had been found guilty and chosen not to appeal, could, after the event, seek to reopen the convictions. If such convictions were to be readily opened, it would be difficult to know where to draw the line or how far to go back. Counsel on behalf of the applicant suggests that there is a readily available line of demarcation which would distinguish those serving sentences from those who had completed their sentences. That, however, would not, in our judgment, be an altogether satisfactory line of demarcation in the case of those who were serving sentences for other offenses as well as for offenses against, in this case, Section 15(1), subsection 1. It is plain as we read the authorities that there is no inflexible rule on this subject, but the general principle is plainly one which sets its face against the reopening of convictions recorded in such circumstances. Counsel submits, and in our judgment submits correctly, that the practice of the court has in the past, in this and comparable situations, been to eschew undue technicality and ask whether any substantial injustice has been done. In suggesting that that is and has been the practice, reference has been drawn to the Queen and McHugh and other cases. This case also drew reference at paragraph 16. So at paragraph 15, Lord Justice Yu's statement was approved by Sir Igor Judge, President in the Queen and Cottrell. Sir Igor Judge said at paragraph 46, in short, the principle is that the defendant seeking leave to appeal out of time is generally expected to point to something more than the mere fact that the criminal are being corrected or developed. If the appeal is effectively based on a change of law and nothing else, but the conviction was properly returned at the time after a fair trial, it is unlikely that a substantial injustice occurred. The tension created by individual and public interests were described by Sir Igor Judge, commencing at paragraph 42 as follows. These cases present issues of great sensitivity and latent tension. Those convicted on the basis of the old law assert that their convictions were based on an erroneous understanding of the criminal law and that they have therefore suffered an injustice. At the same time, there is a continuing public imperative that so far as possible, there should be finality and certainty in the administration of criminal justice. In reality, society can only operate on the basis that the courts administering the criminal justice system apply the law as it is. The law, as it may later be declared or perceived to be, is irrelevant. Change of law appeals create quite different problems to those which arise in a normal case where an individual is wrongly convicted on the basis of the law which applied at the date of conviction. These tensions are not confined to England and Wales. The issue presented itself to the Supreme Court of Ireland in A and Governor of Arborhill Prison. The facts which I already drew the court's attention to earlier, the facts were simple and facts are reported there. And I will just end on, well, I won't take the court back through this paragraph because I think I took the court through it earlier. Continue at paragraph 16. The principle derived by Sir Igor Judge from the reasoning in A and Governor of Arborhill Prison was endorsed by the Supreme Court in the Scottish Appeal of Cadder and Her Magistrate Advocate at paragraphs 60 to 62 and 99 to 103. The Supreme Court applied to Scottish cases the decision of the European Court of Human Rights in Saldos and Turkey that denial of access to legal assistance in police amounting to a breach of the fair trial requirement under Article 6.1 in conjunction with Article 6.3c of the European Convention. The court considered the impact which its decision would have on closed cases. Lord Roger of Earlsferry JSC cited with approval the statement of principle by Chief Justice Murray in A and of Arborhill Prison and continued at paragraph 102. Chief Justice Murray's description of the fact of a decision which alters the law as previously understood can be applied to Scots law. For instance, in Smith and Lees, the court of 5 judges overruled Stobo and Her Majesty's Advocate and thereby laid down a more restrictive test for corroboration in cases of sexual assault. The new test applied to the appellant's case and to other cases that were still live, but it could never have been suggested that the decision meant that convictions in completed cases which had been obtained on the basis of the law as laid down in Stobo were ipso facto undermined or invalidated. Similarly, in Thompson and Crowe, the full bench overruled Balloch and Her Majesty's Advocate and re-established the need to use the procedure of a trial within a trial when the admissibility of statements by the accused is in issue. But again, this had no effect on the countless completed cases where convictions had been obtained on the basis of evidence of such statements by the accused, which judges had admitted in evidence without going through that procedure. So here, the court's decision as to the implication of Article 6.1 and 6.3c of the Convention for the use of evidence of answers to police questioning has no direct effect on convictions and proceedings that have been completed. To all otherwise would be to create uncertainty, and as Chief Justice Murray rightly observes, cause widespread injustices. And the Strasbourg Court has pointed out that the principle of legal certainty is necessarily inherent in the law of the European Convention. I can't pronounce that, Mark X, I think, and Belgium, paragraph 58. In the Irish case, Justice Geoghegan said...
Geoghegan.
Excuse me?
Geoghegan.
Oh, Geoghegan, okay, thank you. Paragraph 286, that he was satisfied that it would be wholly against good order if convictions and sentences were deemed to be lawful at the time they were decided had to be reopened. I emphatically agree. And that policy is, of course, embodied in Section 124 of the Criminal Procedure Scotland Act 1995, which makes interlocers and sentences pronounced by the appeal court final and conclusive and not subject to review by any court whatsoever, except in proceedings on a reference by the Scottish Criminal Cases Review Commission. I would just wish to, more particularly on point, I wish to also to draw to the court's attention the Canadian case of the Queen and English. That's in the, these are the supplementary submissions of the respondent.
Were those sent today?
Excuse me, sir?
Were those sent today, the supplemental submissions of the respondent?
No, those were, the respondent supplemental submissions were filed some time ago.
But wait a moment. The Joint Authorities Bundle has English at page 516.
Yes, my Lord President. Now, in respect to that case, my Lord, that in respect of the case of Queen and English, 1993 Canadian law report, the appellant in that case was convicted by a jury before the decision of the Queen and Bain. And Bain was the Supreme Court of Canada case that declared unconstitutional the Crown's right to unlimited standby in the circumstances of the Canadian legislation. Bain was applied in Tyson by the Court of Appeal of the Eastern Caribbean, and Jamaica Trott relied on Tyson and Bain. In English, one of the grounds of appeal raised was that the jury selection process was unfair, as the Crown was entitled to 4 peremptory challenges and 48 standbys, while the defense was limited to 12 peremptory challenges. In relation to this, Chief Justice Goodrich delivered the decision of the Newfoundland of Appeal, said at page 19. Mr. Coelho, can you assist me as to where that is in the...
I'm sorry, can you repeat that, honey?
Yes, page 19 of this, of English.
Page 533 of the, I think, of the Joint Authorities Bundle.
Yes.
Yeah, thank you, my Lord President. It's under the subheading, the Queen and Bain.
Yes.
Yep.
Section 634, subsection 1 and 2 provides that during the jury selection process, the Crown may stand up to 48 prospective aside until all have been called. Defense counsel contended that this process is unfair. It pointed out that the Crown was entitled to 4 peremptory challenges and 48 standbys, while the defense was limited to 12 peremptory challenges. Crown counsel, in response to this argument raised for the first time on appeal, referred to the decision of the Supreme Court of Canada in the Queen and Perker. Court said at page 391 that a party cannot raise an entirely new argument which has not been raised below and in relation to which it might have been necessary to adduce evidence at trial. This may or may not be a valid answer to the argument by defense counsel because the Crown has not indicated what evidence, if any, it might have offered if the point had been raised at trial. However, the method of forming juries by the use of peremptory challenges for cause, and Crown standbys has been in effect for many years. In Bain, Supra Defense Counsel at trial had objected to this procedure and successfully moved that each party be limited to 4 peremptory challenges and that the Crown be denied the power to stand by jurors, just as in Trott. The Supreme Court of Canada held that the process of jury selection established in the Criminal Code was inconsistent with Section 11D of the Charter, which provides that any person charged with an offense has the right to be presumed innocent until proven guilty according to law in a fair and public hearing by an independent and impartial tribunal. It declared by a majority that Section 634, subsection 1 and subsection 2 was invalid, but suspended the declaration for 6 months. The jury selection process was not challenged by defense counsel at trial. The Bain decision was rendered after the trial took place. At the time of trial, the jury selection procedure had not been declared invalid, and inasmuch as 4 judges on a panel of 7 of the Supreme Court of Canada in Bain suspended the declaration of invalidity for 6 months, the Bain decision cannot be applied retroactively in this case to upset the decision at trial. Bain effectively removes, as of the date of the decision, the right of the Crown to 48 standbys. The decision is inapplicable to this case. And this is similar to the position that we are in with these appeals.
Can you help me on something?
Yes, my lord.
There are 2 different approaches in determining whether a change of the law, in particular, a ruling that the existing law is inconsistent with a constitutional provision, should or could give rise to a successful appeal. In England and like places, that has often been dealt with by saying that you need special leave, effectively, an extraordinary leave to appeal many years after, what may be many years after your original appeal or your original trial, that such leave should only be granted in very special circumstances if there is or may be a probability that if leave isn't granted, you may suffer a substantial injustice. Now that's the looking at the matter of retrospectivity and whether in practice it's going to apply by reference to the question as to whether or not leave should be given. Now, one problem that arises in the present case is that leave has been given in relation to this application, although, as it seems to me, the fact that this court thought that it was an appropriate case to give leave does not of it assume it thought so because otherwise the appellants might suffer an injustice, is not conclusive so as to preclude this court from deciding one way or another whether they would suffer an injustice. But there, as I say, there are 2 different approaches. One is the leave approach, which we see in Ruddock and Vestal. The other is, as it were, the constitutional approach, which we see in the Irish case and in English. And putting it very simplistically, the constitutional approach is that prima facie a decision that something is inconsistent with the Constitution is not to be treated as having retrospective effect, except in special circumstances. I have some difficulty in working out how in the constitutional approach, how the finality principle fits in with the Constitution we see in the Irish and the Canadian case that the judges say, for understandable reasons, decisions that something is, some other provision is unconstitutional should not be regarded as having retrospective effect. There are exceptions to that. But what is, as it were, the source of that? There's nothing in these constitutions, I don't think, which says there's a decision that an existing statute or existing provision offends the Constitution shall not have retrospective effect. Where does the principle arise from?
I think that's, well, from my understanding of the authorities, that's where the principle of finality comes into play, because it's a balance between the public interest in the finality of cases and whether or not the defendant who is saying, but hold on a minute, so-and-so was successful on that point. Why is it I can't be successful, albeit it came after my conviction?
Yes, so one could put it this way, I suppose. It's a general principle of law that decisions made by courts consistently with the law as it then stood should, at any rate, following the expiry of a time for appeal, be regarded as final. It's as simple as that.
That is so, sir. There's a Canadian case that may assist with that point a bit clearer.
Right.
You go so far as to say, Mr. Mahoney,
yes, sir,
that leave may not be granted in an exceptional case, despite the principle of finality, for the question of whether or not there was unfairness to be examined.
Based on the Canadian case of Canto, which I'm about to go to shortly, the principles seem to suggest that cases are usually allowed to reopen. Let's say there's a change in the law that affects sentence. Leave is usually allowed to adjust or reopen cases that have been concluded in respect of sentence. There is no direct challenge to the conviction. And I think we have had that application in Bermuda where, based on the change in the law in regards to sentence, stemming from the Robinson case that I think Mr. Lynch referred to earlier.
This was a mandatory life
imprisonment. Was concluded. Excuse me?
The mandatory life imprisonment issue.
Yes. Other cases concluded, cases were brought back for the sentences to be adjusted in accordance with the change in the law in respect of sentence. But outside of that, once it comes to conviction, the principle seems to be that there have to be finality of litigation, and change in the law does not operate retroactively. Otherwise, another example of that is, for instance, in Canada now, the right for both the accused and the Crown to exercise peremptory challenges in respect of empaneling of jury have been abolished by Parliament. The Federal Supreme Court of Canada has said that it is constitutional. I'm trying to locate their decision, their actual reasoning, but apparently it's not out as yet. But that's another development in the law that may very well make it way to Bermuda in the future. If that is what happened, do we reopen all the cases again? As the law develops, as other areas of the law are declared unconstitutional, do we keep on reopening all the convictions and all the cases?
Right. I wonder, we've had quite a long day. I wonder whether that might be a convenient moment to adjourn.
I would agree, sir.
Right. Well, we'll meet again tomorrow morning at what for you will be 9 o'clock.
Yes.
Very good. Thank you all very much. Sorry.
Before you take off, I just want to confirm with all of the parties that they have access to the documents that the court is using.
You don't have to go there.
I do, yes.
I'm having technical issues with my computer. So my colleague has access, but I'm going to try and sort out my computer tonight.
Okay. And Ms. Greening? Thank you. All right. The judges can retire to the breakout room and all of the other.
No, sorry, I'm so sorry. I'm sorry. There is something I want to raise. I indicated at the beginning that we might want to consider the nitty-gritty of the actual standby process. In the light of Ms. Greening's position, that she accepts what appears in relation to her client's standbys and what happened second time round, we're really only concerned with the other two appellants going into the detail. I'm just thinking about when we should decide what. Have you any idea, Mr. Mahoney, how long you're likely to be on the issues of principle?
I'm
not pushing you in any way. I just want to know.
No, shouldn't be more than another hour because I'm spending time on the principle of finality,
right,
because it laid the foundation for the answers I give.
Okay.
So far.
Well, I wonder whether we should do tomorrow finality, and then there'll be replies from the appellants, and then do the question of new evidence. Will we be able to do all of that tomorrow?
For my part, I did not propose to dwell overly on the new evidence aspect. Your lordships have our submissions and the affidavits. I was hoping to rely upon those, make a few observations, and leave that issue for you to determine. I don't propose to be very long with that.
Right.
I don't know, of course, for Ms. Greening. She also, I believe, has such an application.
Yes. Well, it looks as if we might be able to do all of that tomorrow.
Yes. May I ask, is it still proposed to deal with the individual challenges or standbys,
yes,
that nitty-gritty, or as Mr. Coelho put it to me when I was asking about it, the meat and potatoes of the matter? If that's to be dealt with next week, or is it proposed that we should try and deal with that tomorrow as well?
Would you let us me confer with my fellow judges? Don't go away. If I could go into a breakout room with them.
Certainly.
Yeah, I mean, this is what my point. This is
Good afternoon, Mr. Lynch and Mr. Pettingill.
And
Officer Turner here. Ms. Greening,
Yeah.
your clients wish to have a little tete-a-tete. Are you, after the proceedings, are you available?
Yes, we can do that.
Okay, thank you, sir. Thank you, ma'am.
Do you want to do it combined? I think we want separate ones, don't we?
I would say,
Let's
quick.
go back to the phone call. But
Yeah, I would say give me a, case you can get a call in, Quincy, I'll take it and make it after 5.
Should we
Not
all,
on Zoom.
Should we all deal with it by telephone rather than? Yeah.
Okay, we'll deal with
Or
it.
2 of you could leave the room and one of us can have a face-to-face, whichever way you want to do it.
Probably proceed by telephone call if that's agreeable to you.
Yep.
Yeah, I'll be available.
Ms. Greening?
Yep. Yes, I can be available.
Okay, thank you.
Okay, thanks.
Are your numbers available? I
Yes.
don't.
Sure. I mean, I'm perfectly happy to dial in myself if that's easier.
Can't even get through.
You can't get through.
I can't get through.
Right. Okay.
I
You
can't
call
get
us.
to the prison.
Right. You've got, I think, Miss Tucker's number, haven't you? Yeah. Call her. I'll be with her. Good. All right. Good.
Okay, thank you.
Thanks.
Thank you. My lords.
Not sure whether
We can hear
Pres-
you. We can hear you.
but I'm waiting for the president.
Your
We
microphone.
can see him. We can see him.
Yes.
we can hear you
Yes.
now.
What we have decided is that we are going to do nitty-gritty sometime next week. We think it's a bit much to do the end of the questions of principle and the fresh evidence applications tomorrow. So it'll be sometime next week. And so far as the new evidence applications are concerned, they consist of the wish to reduce the amended affidavit of Mr. Ferbert and the sworn affidavit of Mr. Mohammed.
Yes.
And so far as Miss Greening is concerned, I think the 2 affidavits about what happened during the selection process.
Yes.
That's, we'll have to decide whether or not that is fresh evidence that we should allow to be admitted. Right.
Lords, can I say that I have a very short professional engagement in the morning, which is going to be difficult at this hour to try and break.
Right.
Junior here, she will obviously be in attendance. Mr. Pettingill will be in attendance, and I shall join you very shortly thereafter, if that meets with your approval.
Yes, provided you're content with that.
I am.
We shall miss you for a short while.
For a short while only, yes.
My Lord President. Oh, sorry.
Yes.
With
Yes.
your permission, I just want to correct, having had an opportunity to look at the affidavit of Ms. Alboy, just to make a correction in what I had said in regards to the composition of the jury. For Roberts had 4 whites, 8 blacks. Brandman had 3 whites, 9 blacks, and Smith Williams had 3 whites, 3 blacks, and the 2 alternates were blacks.
3 whites, 3 black. What happened to the
Smith Williams, 3 whites, 3 blacks, and there were 2 alternates who were blacks.
What about the other 6?
Yes, quite. That the juries usually have 12, I think.
No, for Kyrie Smith Williams, there were 6 whites, 6 blacks.
Yes, you said 3.
And then, oh, sorry. And then there were 2 alternates for Williams as well, and those 2 were blacks.
So what?
Right.
We'll deal with that tomorrow.
Until 9 o'clock tomorrow.
Thank you.
Thank you all very, very much.
You.
Shall we go to a
Breakout room, Christopher?
Yep.